Hey, what's up, guys? Welcome to Lawsplaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. And today we have... Oh my goodness. Today we have a case. We have a case coming out of the sunny state of California. Yeah, anyway, this is a Tfue, Turner Tenney, professionally known as Tfue, versus Faze Clan Incorporated, a Delaware corporation. This is an eSports case where we have an eSports athlete, which I guess that's a thing. I don't know. Like, I don't... It's such a weird thing, right? Because esports is so new, and putting E in front of anything automatically means nerd. So we have this like new set of athletes, but they have exceptional levels of skill, commitment. Just like an athlete, they need to practice and hone their skills constantly. So it's this weird sort of brave new world or whatever, where we've got guys at the top of a playing field being now widely watched, monetized maybe in a little bit different way. But of course, the dinosaurs of industry have come in to drop their Mars girl length necks and bite up the foliage that remains, right? And so we've got professional organizations representing players with traditional sponsorship deals and all sorts of stuff. You've basically got teams, right? You've got teams that are involved in these esport sort of things. And every time I say esports, I feel like I age a decade. So by the time I get done with this, I'm going to be in a walker. And my like day nurse is gonna come in, feed me some oatmeal, tell me it's 4 p.m. and then I'm gonna lay down. Let me get a blanket over my shoulders too, because I'm cold, even though it's 87 degrees. But anyway, esports is a massively growing field. It is the League of Legends championship last year had more global viewership than the Super Bowl, which means it has more earning potential than the NFL, which means it's a big deal, huge deal, massive deal. So people are swooping into this stuff to make money all over the place, and of course the athletes and the viewers all stand to lose from the from the help of everyone who can't play, right? That's how this goes. Entertainment works this way. You get a bunch of people who are good at something, and then you get a bunch of other people who aren't to come in and make it less fun for everybody while they make money on it. I don't know what that has to do with the lawsuit. That's just my personal opinion of sporting and gaming organizations and how they tend to end up doing stuff. You add a corporate structure to things, or organizational structure to things, and suddenly they get focused in very narrow and specific ways that don't necessarily have market interests at heart. So anyway, Tfue is a Fortnite player. Faze Clan is his team. He's suing them in California as they are both doing business in California. This is not a federal case. And he's asking for declaratory relief twice, unfair business practices, a violation of unfair business practices, money hadn't received, quantum merit, which is basically that's like money you should receive for partial performance of a contract, breach of written contract, and breach of fiduciary duty. All of these are very fun sorts of legal concepts, and we'll get to explain some of them, I guess, as we go. Bear with me. I do not partake in the questionably legal pastime of esports and esports viewing. I know many of you do. And that's great. That's great. I just, it's not something I've really gotten into at this point in time. So if I miss out on something or terminology, let me say two things about that. First, I'm sorry. And feel free to correct me. But second, this is something that gets overlooked by fan communities all the time. And I have to bring this up anytime I'm covering a new case that has a very specific, versed community that follows it. The judge probably doesn't watch Fortnite on Twitch. I'm not saying it's certain, but I would put big money, big Vegas odds that the judge in this case is likely not a Fortnite Twitch viewer. So it's good to remember that the people deciding this case and weighing out the facts are going to be laypersons. They're not going to be educated. And the education is going to come from a lawyer ham-fistedly explaining to a judge who literally could care less or couldn't care less about esports, what these things are, what Fortnite is, why Maddox is bad at it, all of that stuff. All of that. So bear with me on not knowing things. I'm coming into this, with the perspective of what's a judge looking at this going to start to see, what's a lay person from a jury going to see on this stuff, and we'll kind of go at it that way. Let me tell you my other plan. I have reached out to Beard Harris, Bullock, and Hughes to see if Christina, Amazon Emeritus Christina, who is also an NFL sports agent, would be able to come and discuss this case with me. I thought that would be great, a great subject, because I know that I've been working on getting Christina on the show so that you guys can meet her and kind of learn about her practice. But her practice also involves agency representation of NFL players. So I thought getting her commentary on the esports thing, we could get some comparisons and contrast going between these two similarly tracked but vastly different endeavors. And if you want to know what esports is going to look like in 30 years, you just look at what the NFL looks like now. And I'm sorry if I have just ruined everything about esports, but when there's enough money, that's the way it's going to go, unless we drive it. Now, there's some differences, and I'm going to talk about those differences in a little bit. But we should probably start getting into the case in just a second here. So I'm going to read these first two $20 plus super chats. If you're new to the show, if there's any question that you want answered immediately or relatively immediately, I try and read the 20 plus super chats as fast as possible. And then I will read all of the super chats as we get through the show. And I'll try and add some breaks in to read some, but it all kind of depends on the flow. But if you want to get your question answered kind of right away, the 20 plus chats are a great way to do that. So you don't have to do that at all, but it's just the easiest way to ensure that you get your answer quickly. And I'm also going to pour some whiskey in just a moment. But first, Ink Penification says, "Hey Nick, quick question. Is there a specific field of law that deals with accident related to engineering projects? Stuff like a building or bridge collapsing and the same company that built it is under investigation?" Well, I mean, there's all sorts of fields of law that overlap there. You know, there's regulatory stuff like OSHA and various state agencies that might have work condition, I guess, requirements, making sure building codes are followed and stuff like that. You've got just general personal injury type attorneys. You have commercial attorneys who would specialize in construction and dealing with those kinds of cases. And it really depends on who's injured, depends on what's lost, all of that stuff. But yes, short answer, yes. Next, Lulu CC says, "Jigsaw voice, I want to play a game. Let's take a shot for every time Nick says eSports and see how dead we are by the end of the stream. Is that a good jigsaw? I hope so. I hope so. Let's get some liquid encouragement. What do we got? What do we got? Oh, here we go. All right. We've got some Costco Finnish gin. No, wait, yeah. Small batch rye gin rested in white oak casks for the adventurous rye explorers. So this is Costco gin from Finland. Thank you to Keck7Go. You lovely, lovely, lovely man for sending this out. Woo! All right. That should sufficiently kick in. Woo! That's good. Got a little bite to it. I mean, all gin has a bite to it. It's not very floral. It's interesting. Smells like acetone, but tastes better than acetone. All right. Let's get in. Oh wait. Ron Crossman says Amazons or we riot. Fix this now. We're working on it. We're working on it. Okay. So let's get into this complaint here. Here we go. Here we go. Yeah, it's a brown gin because it's aged. It's aged in casks, right? So it's getting that color from the wood cask that it's aging in. My understanding, most gin is not aged. So yeah. We'll see. Plaintiff Turner, Tenney, professionally known as Tfue, Tenney, alleges cause of action against defendants Faze Clan Incorporated, Faze Clan, and Doe's, John Doe's, Jane Doe's, 1 through 25, collectively defendants as follows. So in covering the Damore case, they did the same thing. They added some John and Jane Doe slots, and basically this looks like a part of the California procedure where they add in a list of defendants that they can amend the complaint to add their names in, as the case goes on. If they're able to discover like more actors than they know exist, or if they're able to discover who is there. Like they know some people are behind Faze Clan, but they may not have all of the names of the people making decisions on behalf of Faze Clan at present. So they add in just a standard list of Does, 1 through 25 in this case, and then what they'll do is at some point they'll ask the court to amend the pleading to include the following people based on their level of involvement and whether the court has jurisdiction over them, or they'll ask to dismiss the Does once they finalize the defendant list. So some states use that system. Other states you just amend the complaint and add people, and you don't have to add in this like proxy list of suspicious anonymous people. But there you go. Gelth says, can we send you a bottle of Aussie rum? You can absolutely do that. Okay, so back to it. Introduction. So this is the intro section. They're gonna let the judge, again, who has no idea what this is, know what this is, to some extent. iRec says, I'm starting an esports team. Do you think you can make a 6-month contract? Yeah, I could do something like that for you. Or I could get someone else who could do that for you. Either way, email me, buddy. rekietalaw@rekieta.org. We'll discuss the particulars, and I could absolutely work something out with you. Work something out. Esports is a new and rapidly growing entertainment format. Unlike traditional sports, significant revenue in the esports entertainment industry is driven by creative content and performances. This is the first major difference. Now, I'm not gonna interrupt every line, but this is the first major difference. Oh, let me finish the sentence. Namely, videos featuring and created by the gamers themselves. Okay. NFL players are not live streaming their own NFL games from their helmets, right? But esports players are constantly, or like a practice session. Like you don't have what's a football name? You don't have JJ Watt with a GoPro on the side of his helmet, live streaming him working over the tackle doll, right? You don't have that. You have, but with esports guys, you have them playing in major events, but you also have live Twitch streams, YouTube gaming streams, Facebook, whatever, where these guys are actually making money from subscribers, and they're monetizing their own content in a different way. Now, that's a difference between major traditional sports and esports, but it's not a mutually exclusive difference. The fact that these other sports players haven't found a way to monetize and do this in their own way doesn't mean that that's somehow like some inherent difference in the medium. It's just a difference in how they're playing out right now. And I think if I had to guess, as this case goes on, Faze Clan is going to hone in on that difference, and they're going to push it to their advantage. And Tfue as well is going to hone in on that difference and say, I have to monetize my content because these guys aren't paying me while they're reaping the benefits and stuff like that. And Faze Clan is going to say, look, this guy's making tons of money that we can't touch because that's his personal stuff. We're only involved in this tiny portion of it, and he's exaggerating how much impact he has, all that stuff. Okay, so that's going to be an important distinction as we go through this. In no uncertain terms, these gamers are artists, entertainers, and content creators. They perform, they act, they direct, they edit, and they stream. Moreover, the content created by these gamers is typically not found on traditional broadcast media such as network or cable television. Just wait. Just wait. You want the real cancer? Wait till you get an NBC exclusive of the next Hearthstone World Finals or whatever, and you can get all your Viagra pill ads and everything through the middle of it. It'll be just great. It'll be just great. They can just advertise the chemotherapy that everyone will need from the cancer of watching esports on a major network. That's coming. Oh my gosh. Ugh. Instead of broadcasting television programs, these gamer content creators stream their videos on online platforms such as YouTube and Twitch. And we've got a footnote here, and it says, for at least the purposes of this complaint, streaming includes both live and pre-recorded creative content that is made available for viewing on these various platforms. The videos created by these content creators / streamers have become increasingly popular, especially amongst younger viewers. Millions subscribe to the content creators / streamers' online channels and or view these videos. As a result, these videos can be extremely profitable. 2, because the esports industry is so new, there's little to no regulation or oversight. There are no real organizations such as unions or guilds to help protect the content creators / streamers that drive the industry. Most of these content creators / streamers are also very young and are often unsophisticated, unseasoned, and trusting. As a result, these young content creators / streamers are susceptible to being taken advantage of and exploited, often by those that are supposed to be looking out for their best interests. Unfortunately, this has become industry standard. Now, I hate this paragraph. I really do. I'm not a big fan of unions or guilds or whatever you want to call them. And I am very much an advocate for free choice and freedom of contract. But they raise some interesting points here about the age and sophistication level of these guys. So they're going to call for regulation in this lawsuit. And there is a parallel case running in California to regulate these esports sort of franchises already. And that's going to be very interesting and possibly destructive to the industry, but we'll see. We'll see. Zero the Slayer says, a friend of mine got the poop kicked out of him at work after telling a customer they had no more hot sauce in the KFC he works at. The police are calling it a consensual fight. What is wrong with our police, Canada? Well, you got it. Canada. Tenney, professionally known as Tfue, is a 21-year-old professional gamer and content creator / streamer. Okay, let me back up for just a second. One thing that is not different, not very, well, it's a little different, but not very different, is the fact that when people are coming into the industry of sports and into the industry of esports, they're both young. They're both very, very young. I think the oldest entry requirement is the NFL, and you got to be like 22 or something like that to get into the NFL. NBA, you have NBA players starting at 18, I think. Wasn't LeBron like 17, something like that? But you have them starting very young. You have baseball players starting very young. There's a limited window in which these guys perform at maximum level, and they have a declining, value the moment they start, because the clock starts ticking on injuries. The clock starts ticking on their reaction time, their muscle mass, their bone density, all of that stuff starts to decline at some point, and the repetitive physical punishment that they go through takes its toll. Esports probably has similar issues in different ways, but there's no difference really, except that some esports players might be below the age of consent, whereas it's unlikely to, or less likely to happen in a professional, traditional sports setting. But they're kind of setting it up that these guys are young. You'll see in a second. These guys are young and they're unsophisticated. Well, I'll tell you who's young and unsophisticated also is every single sports player entering into a contract with an NFL team, an NBA team, an MLB team. These guys have no idea what they're doing either. But they tend to have agents who represent them. Those agents have those agents are licensed and qualified by the overarching organizations themselves, and there's some sort of in-house protection system built in to represent those players, and that's a little bit different than a union, a guild, or government regulation, and that's how I tend to think things should happen. It still, of course, is exploitable, but so is everything. Okay, so he's a 21-year-old professional gamer and content creator / streamer. Tenney performs in and creates popular videos that he streams online. Little narcissistic. No, I'm just kidding. Because Tenney's videos are viewed by millions, sponsors are willing to pay for Tenney to perform in and create videos that will at least in part promote their goods, services, and brands. Razgriz Reborn says, Nick, the youngest age for League of Legends pro players to be able to play is 16. Okay, so there you go. 16 years of age. So we're talking for League of Legends at least. So we're talking about, we're talking about a couple years younger than many of the traditional sports industries, but yeah, not too different. Defendant Faze Clan Inc. is a so-called esports entertainment company. Through Tenney's brief relationship with Faze Clan, he has come to learn that Faze Clan subscribes to the business model described above. Which is interesting because they don't really describe a business model above. So that's a weird statement, but okay. Faze Clan's goal is to essentially own Tenney and other content creators / streamers and professional gamers. Tenney signed a gamer agreement with Faze Clan when Tenney was only 20 years old. That gamer agreement is grossly oppressive, onerous, and one-sided. Indeed, the gamer agreement purportedly entitles Faze Clan to a finder's fee of up to 80% of the revenue paid by third parties for Tenney's services. Now, it's my understanding that Faze Clan has come out and denied this, but I don't know, so I'm just going off of the complaint. When Faze Clan files their answer, or whatever other document they file, hopefully we'll be able to access that and go ahead and use it and see what their argument is. Additionally, Faze Clan uses illegal and anti-competitive provisions in the gamer agreement to severely limit Tenney's ability to compete in the marketplace. Now, before we get wrapped up, if you haven't seen me read through a complaint before, or if you're not familiar with the way complaints need to be worded, this statement has to necessarily be struck from the complaint because it's a legal conclusion. Faze Clan uses illegal and anti-competitive provisions is a legal determination. It's a legal conclusion. And unless they're citing to a specific document that states that a judge has ruled their practices to be illegal and anti-competitive, then it's a legal conclusion without foundation, and it cannot be read as part of this lawsuit. It just can't. So you can't actually write these. People do. You can't include this in your pleadings and expect it to matter in the case. But sometimes there's some psychological value in including some of these statements to let because the judge is going to ignore them. But can you ignore something you've read? Really? It gets kind of difficult to do. These conspicuously anti-competitive provisions, which are probably found in every Faze Clan gamer agreement, undoubtedly violate California Business and Professions Code, which provides that every contract by which anyone is restrained from engaging in a lawful profession, trade, or business of any kind is to that extent void. Now, again, they're making a legal conclusion here, which is not necessarily set out. But the foundation of their claim in this case is based on, it's pretty unique to California because of Silicon Valley, because of all the big tech companies concentrated in a relatively small place, and a lot of highly valuable, highly specialized labor that participates in the tech industry, right? Apple people go work for Microsoft, which goes work for a venture capitalist startup and stuff like that. They used to have very restrictive anti-compete provisions in their contracts, which would effectively, if they left a company, keep them away from working in their profession without moving to like Florida for some long period of time, 3 to 5 years. And with the heavy concentration of those companies in a small geographical area, and some of the biggest companies, California decided that they didn't find anti-competes or non-competes to be really in the interest of the worker, right? So you're actually allowed to kind of headhunt and stuff in California, where in other states you wouldn't be. But that's because if you take a software engineer from Google and tell him he can't compete anywhere that that Google has a major office, you're taking away the vast majority of their opportunity to get a job in their industry at a competitive salary commensurate with their skill. So they got rid of those non-compete clauses, which allows this sort of claim to be made in California. However, again, these are legal conclusions. They're worded poorly. I would not have written this in this way, and they might have to amend their complaint to remedy it, but we'll see. Okay. In simple terms, Faze Clan uses its illegal gamer contracts to limit Tenney to deals sourced exclusively by Faze Clan and to prevent Tenney from exploring deals presented by others. Deals that are potentially superior to deals procured by Faze Clan, and deals that are not saddled with an 80% finder's fee. And now remember, these are going to be written heavily slanted towards the plaintiff party. This does not mean that these are the actual facts. It just means that this is their statement of the facts, and Faze Clan will get a chance to respond to all of this. Faze Clan's gamer agreements are illegal for yet another reason. So here we go. Here's another legal conclusion. Bad to have in a complaint. They violate California's Talent Agency Act, which protects artists from those like Faze Clan that act as an unlicensed talent agency. Faze Clan is not necessarily a talent agency. Again, these are legal conclusions. Very problematic for a complaint. Likely possible to be defeated on a motion to dismiss for failure to state a claim, because legal conclusions are not legal claims. They're conclusions. Though Faze Clan does not hold the requisite talent agency license, Faze Clan continuously and systematically procures and attempts to procure employment and engagements for Tenney as an artist in violation of Labor Code Section 1700.5. As a result of Faze Clan's violation of California's Talent Agency Act, the California Labor Commissioner is concurrently presiding over and considering a petition to determine controversy. A copy of that petition is attached here too as Exhibit 1. But here's the interesting thing. We don't actually know that a controversy exists. The commissioner is concurrently presiding over and considering a petition to determine controversy. So they don't know that they need to be licensed. They don't know that this is a violation of the labor code, and that's a problem for this pleading. Let's see. Rob S. says, the opening of this case is almost verbatim a conversation I had with you-know-who last week regarding eSports. Team owners are pros at contracts, and most players don't even know they need representation. It's criminal. It's criminal. What are you guys doing in the chat? Oh, is it because I said eSports or whatever? Oh goodness. Oh goodness. Let's keep going here. Okay, so here's the footnote on that. Faze Clan's conduct is at issue in the Labor Commissioner's proceeding is summarized as follows. Under Faze Clan's illegal gamer agreements, Faze Clan secures a purported right to procure employment or engagements for young artists like Tenney. To that end, Faze Clan's primary and essential function is to promote and sell Tenney's artistic services and procure sponsorship deals which feature those services. Sponsors pay for Tenney to perform in and create online content and or to model apparel featuring the sponsor's brands. Faze Clan then retains a grossly unconscionable commission for sourcing the deal. Because Faze Clan is unlicensed, it has avoided regulation by California's Labor Commissioner. The need for licensure and regulation, however, is dire. Not only does Faze Clan take advantage of these young artists, it jeopardizes their health, safety, and welfare in violation of the Talent Agency Act, in particular, Labor Code, several sections. Let's see. Faze Clan's illegal contracts and illegal procurements of employment are only the beginning of Faze Clan's misconduct. Okay. This is a strongly worded complaint, but it's not strongly worded in the way that we would want strongly worded complaints. Oh my goodness. Here we go. Though Faze Clan is supposed to be looking out for Tenney's best interest, Faze Clan has done the opposite. As Tenney's agent, Faze Clan receives payment on Tenney's behalf from third parties for the sponsorship deals that included Tenney's services. In breach of the gamer agreement and Faze Clan's common law obligations, Faze Clan has retained those payments without distributing them to Tenney. Equally egregious is Faze Clan's breach of its fiduciary duty of loyalty owed to Tenney. Acting in the capacity of Tenney's agent, Faze Clan rejected at least one sponsorship deal on Tenney's behalf due to a glaring conflict of interest. That's a problem. That's a problem there. The breach of fiduciary duty is one problem. The other potential big problem is it says that Faze Clan has accepted money and not passed it along to Tenney under the agreement. That'll sink them right away if that's true. Chris Nunez says, cheers to you, Lord High Rackers. I'm tardy and a bit naughty, catching you live while on air crew rest in Germany. With all these legal conclusions added, would this complaint damage Tenney's case? Well, it really could get it dismissed. It really is possible to get it dismissed. So we'll have to see. They may have to amend this complaint to omit the glaring lack of, or the glaring legal conclusions. But a judge generally will just ignore the legal conclusions and look for claims within the statements. And on the motion to dismiss for failure to state a claim, Tenney's lawyer would have the ability to clarify any of the paragraphs that are in question and talk about why there's a valid claim in there. HH Gamers also, chat doesn't know how to spell. So there you go. Until now, Faze Clan has enjoyed the fruits of this illegal business model with impunity because no one could or was willing to stand up to Faze Clan. Ooh, they're very powerful. Those days are over. Through this action, Tenney seeks to shift the balance of power to the gamers and content creators / streamers, those who are actually creating value and driving the industry. As a result of this action, others will hopefully take notice of what is going on and help to clean up esports. And by the way, if you guys have time to type in single letters in the chat over and over, I know you've got time to smash that like button. So please do so. Please do so. Liking these streams help them get pushed up into trending. It also helps get them moving along to other viewers after the stream has ended. So I would appreciate if you would take just a moment and click that little smug thumbs up that YouTube has provided. Parties. At all relevant times, Tenney has resided in Los Angeles, California, and Indian Rocks Beach, Florida. Upon information and belief, Faze Clan is a Delaware corporation with its principal and only places of business in Los Angeles, California. The true names and capacities, whether individual, corporate, associate, or otherwise, of the defendants named herein as does 1 through 25 inclusive, are unknown to Tenney, who therefore sues said defendants by such fictitious names. Tenney alleges on information and belief that each of the defendants, including those designated as a doe, are responsible for the events alleged herein and the damages caused thereby as a principal, agent, co-conspirator, or aider and abetter. Tenney will seek leave of the court to amend this complaint to allege the true names and capacities of such defendants when the same have been ascertained. Upon information and belief, defendants at all times relevant to this action were the agents, servants, partners, joint venturers, and employees of Faze Clan, and in doing the acts alleged herein, were acting with the knowledge and or consent of Faze Clan. So there we go. There we go. Next, we've got this court is a proper court for trial in this matter because Faze Clan resides in Los Angeles County, California. Contracted issue was entered into in Los Angeles County, California, and the acts and occurrences alleged herein occurred in Los Angeles County, California. Moreover, California has a strong public policy and interest in preventing those that reside and conduct business in California, like Faze Clan, from engaging in anti-competitive conduct in California in violation of Section 16600. Okay, so that's the intro and the party sections are done. I'm going to read a couple of sub $20 super chats, so those don't fall too far behind. I'm gonna drink some whiskey, and we'll take just a minute. We'll take just a minute, and now is a good time again to smash that like button. And again, it really helps the stream and it helps me out, and it takes very little effort. So if you do that, I appreciate it. Thank you. All right. So let's see what we got here. Solo Beverly says straight and early. Blaine20 says, early but still gay. Sorry, bro. Yorgamund07 says, so early it's like he's compensating for something. Staying Trill, thanks for the donation. David Johnson says, I don't know if you realize, but most of your viewers are probably gamers, especially with the Kick Vic situation. Oh no, I do realize that. I do. John is playing Breath of the Wild. Thanks for the donation. Steven Alvarez says, no one respects esports, only China. China. No one. Esports, they're a new thing. You don't know about them. You never heard of them. Nobody's ever heard of them. Nobody's heard of esports. What do you got? The Chinese? The Chinese are playing esports? What is this? J5 says, I was harassed by Faze for refusing to quit Quickscope in a public COD match. After the match, they booted me using a third-party program. Faze are scum. Let's see. Next is Gelf Walker says, can I send you Aussie rum? The best around? You can. You can actually. I have a P.O. box. And if the P.O. box doesn't work for you, depending on how you have to send it, please message me and I'll try and get you some alternate delivery instructions. Lydia says, would you try the Illik whiskey we sent on stream? I will, and I'll tell you I did yesterday, and it is very, very good. I'm gonna go ahead and finish up this glass of gin and then switch to that in just a moment. Thank you for asking, and thank you so much. It is delicious, absolutely delightful, very smoky. I like it quite a bit. Gelth Walker says, random text here. Notice me, lol. I'm so bored. And then Double A says, I'm a strong, independent complaint who don't need no claim. I don't need no claim. All right. Let me put this gin to bed. And then we're gonna go ahead and jump back into this. Oh, and if you're hanging out while we're at some intimate break time, I feel like there should be some elevator music in the background. I think a little bit later in the show, I'm gonna address a tweet that's come up in which this is why everyone who's a non-lawyer, not asking questions about law but asserting the truth of law on Twitter, needs the gas. We're going to talk about that in a little bit. I'll go into it because I don't think this case is going to take the full show time to go through. It's 23 pages, but I think that includes the other petition. So we'll get through this, and I think we'll probably close out the show talking about that a little bit, and that should be fun. Nothing like a good glass of gin. Where's the cognac? I haven't had any cognac in a while. Ever since I finished off my Hennessy White. All right. Oh my goodness. This is for Lydia. Okay. All right, guys. Why do I tease? I tease because I want you to stay around and watch. Tease because I want you to stay around and watch and just have fun with it. This is a little bit of a new subject, of course, for the channel. And so, you know, want to make sure people stay through the end of this subject. And then any people who are here for this subject, I want them to hang around and watch why you shouldn't go around citing cases that you don't understand on Twitter. So we'll do that. Oh gosh, it's smoking good. Okay. 2 more chats and then we'll get back into it. Randstein Hernandez says, make us whole, praise the sun, glory to mankind, fear the old blood. Gamers know these quotes. There you go. Dirk Limon says, I passed by someone in my local Raleigh supermarket who was a fat middle-aged man that unironically wore a gamer, G-A-Y-M-E-R, in a rainbow pattern shirt. I wonder what the chat thinks of this. Keep up the good work. It's okay to be white. Trump 2020. The gamer shirt's the funniest thing. And then Claire Shackelford says, whether it's Fuentes or Rekieta, seems I'm a knicker to the core. So thank you. Thank you for that. Oh, do you know MGTOW Esquire? I don't. But okay, let's get into the first cause of... Oh, sorry, that was from Talbot Links. First cause of action for declaratory relief against Faze Clan, termination of the gamer agreement. Okay, so a brief sidebar on declaratory relief. Declaratory relief is a remedy the court can impose where the court says, this is wrong and can no longer be. That's that. To actually qualify for declaratory relief, you have to have an actual controversy, some sort of dispute, and the declaratory relief is not it's not a monetary thing. It's the court making a legally binding declaration. So let's get into what that looks like. Let's get into what that looks like. In or around April or May 2018, Faze Clan and Tenney entered into a certain written gamer agreement with the effective date of April 27th, 2018, the Gamer Agreement. The Gamer Agreement was entered into in California. Tenney was only 20 years old at the time, which means he had been a legal adult for only at least 2 years. The Gamer Agreement had an initial term of 6 months and would automatically be extended for an additional 36 months if certain conditions were met. The section of the Gamer Agreement entitled Compensation requires Faze Clan to distribute certain percentages of monies or other consideration to Tenney, quote, from any brand deals featuring Tenney that exist on gamer or company's content creation platforms, e.g. Twitch/YouTube, or social media sites and appearances touring. The Gamer Agreement purported to require such monies to be paid directly to Faze Clan on Tenney's behalf. Faze Clan was required to then distribute those funds, minus Faze Clan's illegal commission, to Tenney. Specifically, the section of the Gamer Agreement entitled Payment Terms requires Faze Clan to distribute certain payments to Tenney pursuant to the following schedule. Quote, all prizes and other income generated in connection with this agreement shall be payable to and collected by company, and company shall account and pay gamer his/her share of such income on a monthly basis within 30 days after the end of each month, provided, however, that any prizes received from tournaments and or matches over $5,000 will be paid to gamer within 30 days of receipt thereof by the company. Okay, so all of the deals that amount to less than $5,000, those get aggregated in, the month ends, and then they have basically the entire next month to make the payment. But anything that's over $5,000 in a single sum would be paid, or from a single predicate act would be paid within 30 days, period. So they don't get that, potentially they have about 60 days to make a payment in theory on some things, but a maximum of 30 days on those larger prizes. So since the inception of the Gamer Agreement, Faze Clan actively participated in the procurement and negotiation of sponsorship deals, which included Tenney's services as an artist. Faze Clan frequently and continuously presented such sponsorship opportunities to Tenney. Under these proposed sponsorship deals procured by Faze Clan, sponsors would agree to pay monies so that their brand's goods and or services would be promoted in connection with videos featuring Tenney's performances and created by Tenney and or live performances. Stated differently, Tenney would perform creative services, performing in and creating video content and or live performances in connection with these sponsorship deals. By way of example only, Tenney created and performed in a video for sponsor Digital Storm, promoting Digital Storm's products that garnered over 19 million views. Faze Clan has also procured and attempted to procure modeling engagements for Tenney, where he would model apparel and jewelry for certain sponsors. The real question here is does anybody want to see Tenney in apparel and jewelry? I don't know what he looks like. So, of course, a really interesting thing is that they have very selectively quoted out of these contract provisions rather than providing the complete paragraph in a block quote or even an image of the complete paragraph or attaching the contract to the complaint. All of those things, those other things would have been more helpful than just taking a quote with lots of ellipses, which means lots is left out. Now, ultimately, it's not going to matter because if you're misleading the whatchamacallit, if you're misleading the court, right? If you're misleading the court by selectively quoting in a deceptive manner some provision of the contract, it's going to come around to bite you in a very, very bad way. And so I want to put this out there because Faze Clan, I believe, has come out and said that they didn't collect on all this stuff and this isn't true. And the representations that are made here are that Faze Clan collected money and didn't pay it to Tenney. Now, Faze Clan didn't actually collect any money and therefore didn't pay it to Tenney because they didn't collect money, then he's going to be misrepresenting potentially to the court that he's entitled to some money that they've actually received. If you mislead the court into thinking money has changed hands when it hasn't, the court will hate you. So I don't assume that he's doing this. I don't assume that. But it makes it kind of difficult when we're only given a snippet of the provision and not the entire paragraph of the contract, which personally I would add in the entire paragraph of the contract, and I would maybe do, capitalize or italicize the emphasized portions that I wanted to draw the judge's attention to. But I would add in the entire portion of the contract because it just allows for a more complete thing for the judge to read. And to me, I just like the way it looks better. But it's personal preference. I'm not suggesting that anything nefarious is happening here, but they do have to be a little bit cautious to not misrepresent what's going on. Paragraph 16, upon information and belief, Faze Clan has received payment of funds on Tenney's behalf from third parties under the sponsorship deals that included Tenney's services. Faze Clan has retained those payments from third parties without distributing them to Tenney. Faze Clan's continuous failure to distribute these monies to Tenney constitutes a material breach of the gamer agreement. Again, if they are collecting money, that's true. The really interesting thing would be if Faze Clan said, actually, we're not collecting any money, and Tenney is also not collecting money from the deals, then Faze Clan may be in breach of fiduciary duty because they're not following up on their end of the agreement to actually procure the payment from the third party. Again, it's hard to say. I don't know the facts from the inside here. We're just looking at this from the outside. Let's see. Mike456W says, saw you on Fortnite Guy's channel. Who's Fortnite Guy? All right, next. On or about September 26, 2018, Tenney, through his counsel, sent Faze Clan a letter informing Faze Clan of Tenney's intent to terminate the gamer agreement pursuant to Section 6D of the gamer agreement's terms and conditions based on Faze Clan's numerous breaches. In response to Tenney's September 26 letter, Faze Clan disputed Tenney's termination of the gamer agreement. In an abundance of caution, on or about May 20th, 2019, Tenney, through his counsel, sent Faze Clan yet another letter reiterating that Faze Clan was in breach of the agreement due to its failure to distribute all payments or other consideration to Tenney as required by the gamer agreement. An actual controversy has arisen and now exists between Tenney and Faze Clan concerning their respective rights and duties with respect to the gamer agreement. Again, this is a necessary condition for declaratory relief from the court, is that an actual controversy has to exist, and you need the court to declare the outcome of this thing. Faze Clan apparently disputes that the gamer agreement was terminated based on Faze Clan's material breach. Faze Clan further contends that Tenney continues to owe Faze Clan various obligations under the gamer agreement. Conversely, Tenney contends that the gamer agreement was terminated based on Faze Clan's material breach and or for cause, and disputes that he continues to owe Faze Clan any further obligations. A judicial declaration is necessary and appropriate at this time under the circumstances so that Tenney may ascertain his rights and duties under the gamer agreement. So, Judge, tell me what I have to do for them, please. Accordingly, Tenney seeks a declaration that as a result of the termination of the gamer agreement based on Faze Clan's material breach, Tenney does not continue to owe Faze Clan any further obligations under the agreement, except possibly any contractual obligations that survive the gamer agreement's termination based on the material breach, footnote 3. This assumes that the gamer agreement is not void ab initio, which means from the beginning, from the onset, out of the gate, however you want to read that, due to Faze Clan's continuous and systematic violations of California's Talent Agency Act. That issue is being adjudicated by California's Labor Commissioner. So California's Labor Commissioner could come in and say that all of Faze Clan's agreements, because they're unlicensed, are therefore void, meaning they're done. They're not only are they not enforceable, they're not salvageable. Void contracts are gone. So failing the commissioner's ability to do that, or failing the commissioner's authority or whatever to declare that, then they're asking the court to declare that Tenney's specific contract is no longer valid due to breach. Mithrin Emrys says, it would be interesting if Tenney is living in housing provided by Faze Clan and they try to claim monies due to be paid to him were deducted from payouts for rent, meals, expenses, etc. I would love to see the contract. Oh, me too, man. Finding this contract would be great. There's a block quote here coming up. So that'll be interesting. But man, I would love to see a full copy of this contract. Tenney, buddy, if you're out there, or Faze Clan, if you guys are out there and want to actually go through the contract, and assuming it's not, when it probably is protected by some sort of confidentiality, but if you determine that breach has occurred and you want to go through that contract or talk about it or have me go through it, please do not hesitate. Hit me up by email. I would love to take a look at it and see if it were possible to discuss in a public manner. I think that'd be really educational for people. Plus, there's a lot to discuss about the sophistication level of these contracts, the sophistication of the two parties involved making the contract. Man, that's juicy stuff right there. Okay. Second cause of action. Declaratory relief against Faze Clan for business and violations of Business and Professions Code 16600. Gamer agreement contains several provisions that constitute illegal and anti-competitive restraints on trade in violations of Section 16600. Notably, Faze Clan uses Section 5 of the Gamer Agreement's terms and conditions entitled Exclusivity and Matching Right to illegally restrain Tenney from lawfully pursuing his trade and profession. Section 5A of the agreement's terms and conditions states as follows. Throughout the term, the exclusivity period. So this is a defined term that's going to be defined in a section higher up in the contract. The exclusivity period will be a negotiated, agreed point of time where Faze Clan has exclusive access to Tenney's services, to the content that he creates, to the advertising stuff, or maybe the exclusive right to procure sponsorships. It's hard to say exactly what that's for, but that's going to be a defined term. That's what the capitalization and the quotes here indicate. Unless Gamer has obtained company's prior written consent, Gamer shall not, 1, provide services or otherwise work for or be employed by a gaming company or other gaming brands or any companies that already have an agreement with company. So this is a provision of a non-compete. 2, appear in, sponsor, or be sponsored by, or otherwise promote or endorse, directly or indirectly, any brands, products, or services other than the brands, products, and services approved in writing by company. So this means that he could be in breach of this contract by merely having some sort of branded product behind him, drinking the wrong soda, for example, or the wrong G Fuel. 3, promote, sponsor, endorse using gamer's name and likeness or otherwise, or render services for or on behalf of any companies with products or services competitive with a product or service of company, or a sponsor or advertiser of company. When you add in that sponsor and advertiser language, this gets really, really broad really fast, because it's not limited to exclusively like gaming keyboards or headsets, right? Anybody could sponsor the company. Teespring would then limit his ability to wear shirts. That'd be... The parties acknowledge and agree that with respect to companies' prior approval over any sponsorship and or endorsement opportunity, that companies shall be entitled to negotiate the terms and conditions of any such opportunities presented to gamer with the goal of increasing the value of such opportunities to gamer and company, and that throughout the exclusivity period, company will also work to source sponsorship and or endorsement opportunities on behalf of gamer. This is a really interesting provision, but 1 second, let me read Mithranimrus. Mithranimrus says, if it is anything like a contract for American Idol, America's Got Talent, or The Voice, it will be disgusting. Often runners-up come off much worse than the winners in those situations. Please, Faze Clan, send Rackets a copy. We'll see. And Arbiter 117, thank you very much for the donation. But let's talk about this section right here. The parties acknowledge and agree that with respect to companies' prior approval over any sponsorship and or endorsement opportunity. So the company has prior approval over any sponsorship and or endorsement opportunity, right? Yeah, they have prior approval over any sponsorship or endorsement opportunity. So not only do they have their purported 80% commission on any opportunities that they source, but they have negotiating authority over every single third-party sponsorship that he would get under the contract. Whether or not they're enforcing that is one thing. But the plain language of the text says, the parties acknowledge and agree with respect to companies' prior approval over any sponsorship and or endorsement opportunity, companies shall be entitled to negotiate the terms and conditions of any such opportunities presented to gamer with the goal of increasing the value of such opportunities to gamer and company, and that throughout the exclusivity period, company will also work to source sponsorship and or endorsement opportunities on behalf of gamer. Now, because the company is taking a cut, they believe that they have a fiduciary obligation to aim to maximize the value of any sponsorship. That means, like, let's say Tfue's buddy wants to open a company that sells, that manufactures and sells mechanical keyboards, right? And Tfue wants to promote that, and he knows his buddy doesn't have a lot of seed money to do this. It's all wrapped up in manufacturing and sourcing of the inventory. And so he says, you know what? I've got a big platform. Lots of gamers watch my stuff. I'll endorse your product and you know, promote it and show it on the stream. And actually, you don't owe me anything, you know, to do this because you're my friend. You have been forever. The Faze Clan here could come in and say, no. You can't do this for less than X amount of dollars, like, or some sort of cut of the revenue. No matter what Tfue wants, Faze Clan would have the opportunity to come in and negotiate that. That's not necessarily nefarious. I just want to lay out what that actually means because it's pretty interesting. Arbiter 117 says, me and my girlfriend like to watch your videos and live streams. It's very educational. Hey, thanks, buddy. I try very hard to make it so. Okay. Yeah. Okay, Section 5B of the Gamer Agreement's terms and conditions states as follows. In addition to the foregoing, during the exclusivity period, companies shall have approval over any and all third-party requests for gamer services. Accordingly, gamers shall notify company immediately after gamer's receipt of the third-party request. This could honestly apply to, like, a request to appear on someone else's show. In theory, it could, like, him showing up in someone else's match, like not playing live or whatever. If he just wants to join friends and one of them is broadcasting, Man, that's restrictive. Accordingly, gamers shall notify company immediately after gamers' receipt of the third-party request. Nothing in this paragraph shall in any way obligate company to approve any third-party request or be deemed to limit the exclusivity provisions set forth in the agreement. Gamers shall also be prohibited from entering into any agreements which require any third party to exploit any merchandising in connection with gamers' business or businesses to the exclusion of company's ability to exploit any merchandising with such third party. So there you go. There you go. On their face, sections 5A and 5B of the Gamers Agreement's terms and conditions constitute illegal restraints on trade and anti-competitive agreement in violation of section 16600. Indeed, these provisions explicitly purport to prevent Tenney from providing certain services, working or being employed in certain spaces, or otherwise competing in the marketplace. Yeah, they're really, really overbroad here, especially with the nature of the profession that he's in. Like, if this guy wants to go and join a group and he's not streaming, but one of them is, and that's monetized, in theory, he's in violation of he's in breach of his contract. Even if he's just casually playing, you know, he would have to play anonymously somehow. Which would be hard. He'd have to come up with, you know, a different username and all sorts of stuff. He'd have to actively conceal his identity. As sections 5A and 5B of the Gamers Agreement's terms and conditions limit the ability of Tenney to compete in the marketplace and lawfully pursue his trade and profession, those sections are void and unenforceable. All right. Section 5C of the Gamer Agreement's terms and conditions states as follows. If at any time prior to the end of the exclusivity period or within 3 months thereafter, gamer receives an offer from another Fortnite team to join such team upon lawful termination of the agreement by gamer, gamer shall be obligated to provide the offer to company and the identity of the party providing the offer, and company shall have the right to match such offer during a period of 15 business days following company's actual receipt of the offer. The matching right. If company elects to exercise the matching right, company shall inform gamer within said 15 business days period, and company shall automatically have exclusive rights to gamer services on the same terms as the offer, as supplemented by all of the terms and conditions of the agreement not inconsistent therewith. If company elects to move forward with the matching right, provided that company shall not be required to match any term which may not be as easily met by one person as another, and or any term which is not readily reducible to a determinable sum of money, provided that company, so like, those terms of the agreements that they're talking about would be stuff that one team could provide, like exclusive team merchandise for the other team. Obviously, Faze Clan wouldn't be able to provide exclusive merchandise from the other team as part of the matching agreement. So they wouldn't be able to do that. And anything that can't be reduced to some sort of monetary value gets ignored. So there you go. Provided that company decides not to go forward with the matching right, and provided that gamer is not in breach of the agreement, gamer shall be free to enter into an agreement based on the offer. If gamer does not accept the offer, then company's matching right shall revive and shall apply to any future offer. That's weird. Any future offer should be within the 3-month period thereafter, or within the exclusive. They should add in within the exclusivity period or within the 3 months thereafter to this. Otherwise, it looks like they're trying to apply that infinitely going forward into the future. But 3 months would be an extremely short non-compete in general terms. But I believe California has outright outlawed non-compete agreements entirely. So on its face, 5C, the Gamers Agreement's terms and conditions, at least in part, constitutes an illegal restraint on trade and anti-competitive agreement in violation of section 16600. That provision explicitly purports to prevent Tenney from providing services to any Fortnite team following the term of the agreement if Faze Clan exercises certain matching rights. As sections 5C of the Gamers Agreement's terms and conditions limits the ability of Tenney to compete in the marketplace and lawfully pursue his trade and profession, that section is void and unenforceable. Yeah, again, this is a unique brand of California employment law. Section 4C of the Gamer Agreement's terms and conditions entitled Gamer Name and Likeness also purports to provide Faze Clan with certain limited rights to use Tenney's name, image, voice, and likeness, the Tenney publicity rights, in connection for Tenney's purported services to Faze Clan. While on its face, 4C does not prevent Tenney from using or licensing the Tenney publicity rights in connection with services to others. Upon information and belief, Faze Clan seeks to use 4C in conjunction with 5 to prevent Tenney from providing certain services, working or being employed in certain spaces, or otherwise competing in the marketplace. To the extent used to limit Tenney's ability to compete in the marketplace and lawfully pursue his trade and profession, Section 4C is void and unenforceable. So they're going to argue that Faze Clan retains exclusive rights to his gamer name and likeness for a period of the exclusivity period, even if he is traded to someone else, which would then force him to do a name change, probably a channel change, and all of that stuff under the thing. But that would be an inconsistent term in the contract, and I think the other one would, the idea that they're severing their rights with him, that it wouldn't follow that they retain their rights here. But it's better to be safe than sorry. Mithrin Emmer says, wait, does that mean Rice Scum had to pay anytime Faze Banks appeared in one of his videos, even tangentially? Because that would be simultaneously hilarious and sad. Dude forking over cash for his roommate appearing. In theory, yes. In theory, yes. Again, that's according to the plain language of the contract. I mean, you read it. You're a learned man. You can read that and come to that determination. I don't think that's unreasonable to determine. However, whether or not they're enforcing that is a different story. But it certainly seems to exist within the contract, which seems to meet the onerous test that they were talking about earlier. CW asks if these strike me as standard. I have no idea. They probably are standard, even though they appear to be very exploitative, but they probably are standard. That doesn't make them correct. Okay. To the extent the gamer agreement is not void ab initio and has not been terminated, Tenney is entitled to a judicial determination. Sections 5 and 4C of the gamer agreement's terms and conditions are void and unenforceable pursuant to Section 16600. Accordingly, he requests a judicial determination declaring those provisions are void, illegal, and unenforceable, or at least partially unenforceable, as they violate Section 16600. Tenney further seeks a declaration that he does owe Faze Clan any further obligations under those provisions of the gamer agreement. Again, Judge, please look at this and tell me what I have to do. Tell me what I'm obligated to do at this point. All right. I want to read a couple more of these chats just to keep on top of them today. Broken Down Critter says, hey, Nick, go find your email with the subject RE Absinthe Offer ready to mail and tell me where to send it before my bottle's empty and I drink yours, I guess. Sleeping now. Catch the show later. I will do, buddy. I will do. Benjamin Culp says, saw some Jameson Caskmate IPA edition in the store today and decided to go out on a limb for your stream today. Always look forward to your streams. Hey, thanks, man. I appreciate it. The Game Idea Guy says, check out the Game Idea Guy to hear game ideas, commentary, see gameplay, and his pitch for Switch playlist that has predicted Nintendo Switch games. Game Idea Guy says, thanks for being my billboard, Nick. You're welcome. You're welcome. Internet Tab says, illegal gamer agreements. And Super Saiyan Serg says, take my free super chat. And I will do that. Thank you so much. Thank you. Third cause of action. For violation of unfair business practices. Under California Business and Professions Code Section 17200 et sec against Faze Clan. This is a claim for violation of California Business and Professions Code Section 17200. Section 17200 precludes a person or entity from engaging in unfair competition defined as business practices that are unlawful, unfair, or fraudulent. Faze Clan's use of sections 5 and 4C of the Gamer Agreement's terms and conditions restrains Tenney from engaging in his lawful profession, trade, or business in violation of section 16,600, and therefore constitutes an unlawful and or unfair business practice under section 17,200. This is a provision of the California Code, which basically says if you violate any of the other labor or business codes out there, that's an unfair business practice, and you're entitled to financial compensation. You get compensation under this section because, for example, he doesn't necessarily get monetary relief for his declaratory acts violating section 16,600. So section 17,200 steps up to say, you know what, they did actually violate these things. It's unfair business practice, and there is some sort of monetary relief that is provided to them in addition to whatever other relief they may be entitled to. So that's why this exists. Tenney has suffered injury in fact or is being threatened with injury in fact as a result of Faze Clan's unfair and unlawful business practices described above. Such injury in fact has been occasioned by the loss or threatened loss of the ability to freely engage in his lawful profession, trade, and or business. Tenney respectfully requests that this court permanently enjoin, well, it says permanent enjoin, needs a LY, Faze Clan and anyone acting in concert with Faze Clan from continuing to engage in the unfair and unlawful business practices alleged herein. Tenney further respectfully requests an award of restitutionary relief requiring Faze Clan to disgorge any monies earned by Faze Clan as a result of its unfair and unlawful business practices, including without limitation the revenues and profits illegally made by Faze Clan as a result of such unfair and unlawful business practices. So there you go. Fourth cause of action. For money had and received against all defendants. Tenney realleges, that's a throwaway line. Faze Clan and or other defendants received money from third parties that belonged to and or was intended to be for the benefit of Tenney. That is, upon information and belief, Faze Clan has received payment of funds on Tenney's behalf from third parties under the sponsorship deals that include Tenney's services. Those monies were not used for the benefit of Tenney, were not provided to Tenney. Faze Clan has retained payments from third parties for Tenney's services without distributing them to Tenney. Based on defendants' retention of Tenney's monies and failure to distribute the same to Tenney, Tenney is entitled to damages and amount to be proven at trial. They probably need discovery to show how much they've taken in. Fifth cause of action, quantum merit against all defendants. Assuming the gamer agreement is void and unenforceable, Faze Clan and other defendants must compensate Tenney for the services he provided for various sponsors. Quantum merit is a equity, and it's a form of equitable or quasi-contract relief. If you don't have a contract, there's no relief under the contract, right? If the contract is void, there's no contractual obligation to pay or perform. But he has done work under the assumption that he would be paid in a specific way under the contract. So quantum merit is basically, it's like earned income that he was induced to perform under a set of terms that were understood by both parties, and whether or not the contract is enforceable, he needs to be compensated at least so much as the work he performed. It's not a full relief. If it was a full breach of contract relief, he would be entitled to the entire contractual amount, whatever that may be, and breach would have anticipatory damages, from future earnings that would have been earned under the contract if it was breached early, and all of that stuff. Quantum merit just says, this is what I've done. I can collate all of the hours worked. I can show all of the sponsorship deals that I've done. This is how much they should be worth. I get paid that much money, just that much, but nothing in the future. So this is it's a quasi-contractual relief in the event that the court finds that the contract is unenforceable. This can provide financial relief in a different way. So I hope that makes sense. I hope that's helpful. These are kind of deep terms that most normal people don't ever have to deal with. Assuming it's void and unenforceable, Faze Clan and the other defendants must compensate him for the services he provided for various sponsors. Throughout the course of his relationship with Faze Clan and at Faze Clan's request, Tenney provided the services alleged above. In particular, Tenney provided services to various sponsors. Faze Clan and the other defendants benefited from those services. Though Faze Clan and other defendants benefited from the services provided by Tenney, defendants have failed to and have refused to compensate Tenney for the value of his services. Again, Faze Clan has retained payments from third parties for Tenney services without distributing them to Tenney. Tenney is entitled to fair and reasonable value of the services he provided, which would equal at least any amounts paid to defendants by third parties for or related to Tenney's services, if not more. Tenney has been damaged based on defendants' retention of monies paid for Tenney's services and failure to distribute the same to Tenney. Tenney is entitled to damages in an amount to be proven at trial. 6. Cause of action: breach of written contract against Faze Clan. Assuming the gamer agreement is valid and enforceable, Tenney did all or substantially all of the significant things that gamer agreement required Tenney to do. In particular, Tenney provided artistic services to sponsors. Faze Clan has retained payments from third parties for Tenney services without distributing them. Accordingly, Faze Clan has breached the gamer agreement by failing to distribute his payments. Based on such breach, Tenney is entitled to damages in amount to be proven at trial. So again, covering both bases. If the commissioner rules that the contract is void and unenforceable, he needs to have the quantum merit provision, and if he does rule that it is not void and it is enforceable, then they're on the hook for breach, according to him. 7th cause of action: breach of fiduciary duty. Irrespective of whether Faze Clan qualifies as a talent agency, as that term is defined by California's Talent Agency Act, Faze Clan acted as Tenney's agent. In particular, Faze Clan acted as Tenney's agent in sourcing and negotiating sponsorship deals that would offer Tenney's services. Accordingly, Faze Clan owed Tenney a fiduciary duty by virtue of such agent-principal relationship. Yes, if you are an agent of someone, you have a fiduciary duty to act in their best interest and to use your agency authority to prevent them from loss to the best of your ability. As a fiduciary, Faze Clan owed Tenney a duty of undivided loyalty, was required to act with the utmost good faith and in Tenney's best interest, in particular in connection with sponsorship and or any other deals that may be brought to Tenney. Faze Clan knowingly acted against Tenney's interest by passing on and or preventing Tenney from moving forward with a sponsorship/brand deal with HyperX. Upon information and belief, Faze Clan passed on that sponsorship deal due to a conflict of interest. Faze Clan perceived that HyperX was a competitor of another sponsor that did business with Faze Clan. As a result, Faze Clan elected to cause Tenney to pass on the HyperX sponsorship deal because that deal conflicted with Faze Clan's own interest. Its interest not to upset another sponsor and potentially jeopardize and negatively impact its relationship with that sponsor. Faze Clan also knowingly acted against Tenney's interest by preventing third parties from helping Tenney source sponsorship or other deals. Consequently, Faze Clan breached its fiduciary duty of undivided loyalty owed to Tenney. Yes, if you're acting as someone's agent, you don't get to take your own considerations into account when you're making decisions as their agent. So there is a conflict of interest between acting as an employer, or I guess as like a team manager and an agent at the same time, which is why typically in regular sporting regular sporting industries, you have players having individual agents representing them for sponsorships and all of that stuff, and then you have a team that they're a part of that handles things differently. That way there's no apparent conflict and no breach of that undivided loyalty. Because if your agent is trying to procure a sponsorship which conflicts with the team's business, and they bring this, the team is going to have a contractual provision that says that you can't engage in any sort of sponsorship from this, from a company that conflicts with one of our other sponsors or whatever. The agent would bring that sponsorship and the team would say, no. He's bound by this. You're acting as his agent. You can't do that. But when you're acting as both like an overarching entity and an agent, you run a real risk of conflicting with your own interests, or conflicting your own interests with your principal's interest. And when those two match up, you technically have to act in the interest of your principal, because as the agent, you are acting in their best interest, not yours. So that would be a real problem if this can be proven to be true. Very, very bad. Very bad thing. Very bad thing. By the way, this episode not brought to you by HyperX, but I do have a pair of these HyperX headphones. They are nice. I like them. Hey, HyperX, if you're out there, Hit me up. No, I'm just kidding. Upon information and belief, at least some of the other defendants aided and abetted in Faze Clan's breach of fiduciary duty as alleged above. Those defendants knew that Faze Clan was acting against Tenney's best interests as alleged above. Moreover, upon information and belief, those other defendants gave substantial assistance and or encouragement to Faze Clan by actively participating in Faze Clan's rejection of HyperX sponsorship deal on Tenney's behalf, as well as the decision to preclude Tenney from using third parties to help source deals. That's good. Man, that is good. As a direct and proximate cause of Faze Clan direct and proximate result of Faze Clan and the other defendants' conduct, Tenney has suffered and continues to suffer damages in amount to be proven at trial. Specifically, Tenney was prevented from moving forward with certain deals that would have realized substantial revenue for Tenney. Faze Clan and the other defendants were substantial factors in causing this harm. The acts of Faze Clan and the other defendants, as alleged herein, were willful, wanton, and oppressive, and were taken with knowledge that they would harm Tenney. As a result, Tenney is entitled to an award of punitive and exemplary damages in an amount sufficient to punish defendants and to deter similar conduct. Wherefore, Tenney prays for judgment in favor against defendants, and each of them as follows. Oh, this is nice. They have the cause of action laid out very clearly as to what relief they're seeking for each one. First cause of action for a declaration that as a result of the termination of the gamer agreement based on Faze Clan's material breach, Tenney does not owe Faze Clan any further obligations under that agreement except possibly any contractual obligations that survive the gamer agreement's termination based on a material breach. 2, for the costs of suit incurred herein, and 3, for such other and further relief as the court may deem just and proper. So they are asking for basically attorney's fees and filing and case fees in this. I'm not sure if that's in the declaratory relief section under California. The risk in Minnesota of asking for the costs of the suit would be that when you ask for costs of the suit, the other party would be entitled to them if you fail. I don't know if that's true in California. I would guess it is. I would guess it is. On the second cause of action for declaration that 5 and 4C of the gamer agreement are void, illegal, and unenforceable, Tenney does not owe any further obligations, costs of suit, and any other relief as proper. For an order, third cause of action, temporarily, preliminarily, and permanently enjoining or stopping Faze Clan and anyone acting in concert with Faze Clan from attempting to enforce Section 5 and the illegal portions of Section 4C of the gamer agreement. For disgorgement and restitution of any monies received by Faze Clan, disgorgement would be turning over any that they've held. Restitution would mean repaying any that they don't any longer hold. Of any monies received by Faze Clan as a result of its unfair business practices and unlawful conduct, including without limitation the revenues and profits illegally made by Faze Clan as a result of such unfair competition. Costs of the suit and other relief as necessary. Fourth cause of action, damages in an amount in excess of the court's general jurisdiction to be proven at the time of trial. General jurisdiction in this court appears to be $25,000, so they're looking for an amount in excess of $25,000, but not marrying themselves to any particular number. For prejudgment interest at the maximum rate permitted by law, so they're asking for interest from the time of filing. So if this case drags out for 3 years, they're going to tack 3 years of interest on from the time of filing this action. For the cost of suit and any other relief they may deem just and proper. McGraybush says, sitting here with my Dalwhinnie 15 year, a great scotch. And by the way, if you like that one, try the Distiller's Edition Dalwhinnie. Also fantastic, and a real good, a real just smooth and sweet and subtle purchase. It's about $5 to $10 more than the 15 year, but it's worth it in my opinion. Recently lost my job, so I get to take some time off and try to get my voiceover job up and running. I've really enjoyed your insight, especially regarding Vic. Keep up the great work. Hey, best of luck to you, buddy. Best of luck to you, buddy. I have no idea how you even break into these types of industries, but I do hope you I really do hope you have some success in doing that. On the 5th cause of action for damages in an amount in excess of the court's general jurisdiction to be proven at the time of trial. Same thing here. Prejudgment interest. And then same on the 6th cause of action. So that's that. 7th cause of action includes punitive and exemplary damages. Punitive and exemplary damages, again, are used to punish the party for not only just doing a thing that's unlawful, but for doing it in a way that the court specifically wants them to never ever do again, and to send a message to other people who are doing it that they should stop immediately, because what they're doing is grossly unfair, against public policy and all that stuff. Let's see. Signed, Friedman and Tatelman, Brian J. Friedman, Esquire, Jesse A. Kaplan, Esquire, attorneys for plaintiff, Turner Tenney. So that's nice. It's signed by a named partner of the law firm. I know nothing about this guy or the firm itself, but it's always nice when you hire a named partner. I'm guessing, from what I understand about Tfue, that guy probably makes significant income and is able to retain very competent and experienced and effective counsel. So we'll kind of see what else is in this document. We got a couple more pages. Oh, here's before the Labor Commissioner of the State of California. This is a petition to determine controversy in regards to that contract. So there's a couple super chats to read. Should I do that? Yeah, there's like just a couple super chats. And then should I do that Twitter thing to break it up a little bit? And then we can go through this complaint. It's about 5 pages of this second complaint. We'll do that. That is good. Lydia, you're spoiling me, because I'm not going to be able to get that bottle. I'm not doing Ace Attorney tonight. But I will do Ace Attorney this week. Just not tonight. So let me read these chats, and then we'll do the Twitter. We'll do the Twitter thing, and then we'll get back to the complaint, and that should take us to close, and that'll be perfect. Super Saiyan Serg says, take my free super chat. I will. Thank you. Solo Beverly says, Nick, can you plug Vic's latest tweet for North Carolina fans? Yeah, let me do that right after these super chats. And Pixlexia says, still want to see you play Dark Souls. We'll keep harassing you till it happens, but really keep up the good work. Please say, praise the sun as Russell Greer. Oh, praise the sun. Praise the sun. Praise the sun. Let's see. Let me pull this up here. What do we go? We go, whoops. I'm in the wrong thing here. Let me pull up Vic's Twitter. What am I doing? Oh my goodness. I think I know what this is about. This is about a June 1st appearance, I think. Okay. Let me go. Oh my gosh. All right, so this is Vic Mignogna. Here we go. North Carolina anime fans. Unfortunately, I won't be in Raleigh this year, but I will be here. I hope lots of you can come out to see me. Well, Vic, don't link to a Facebook post. God. Hold on. All right, here we go. Let me, I gotta get rid of this stupid thing real quick. There. There. I don't need my... Oh, come on. Can I... Hold on. Facebook likes to show all of my information. So I want to get rid of all of that. Okay, here we go. Here we go. Hopefully you guys can see this. Meet and greet with Vic Mignogna, voice actor of Broly, hosted by the Jacksonville Mall. That's June 1st, Saturday, June 1st, 11 a.m. to 7 p.m. Eastern Time at the Jacksonville Mall in Jacksonville, North Carolina. So if you're a fan of Vic Mignogna, definitely, and you're in the North Carolina, Jacksonville area, go check it out. And check him out. Raleigh is it Raleigh SuperCon or whatever? Is that the one? I think they uninvited Vic a while back and have decided to just... Seems like they've decided to go ahead and breach their contract. But yeah, this is a place where you can go interact with Vic. I've heard there's quite a bit of interest on... I have no idea how many people are planning on going to this thing. Let me see if it says. Sometimes it says how many people are interested. There's 64 going, 96 interested on Facebook alone. So make sure you check this out. I'm going to go ahead and share this after the stream. But go visit Vic at the mall. Say hi, especially if you support him. He would love to have people who support him come out and say hi. Trust me, like there are a lot of people, a lot of these guys really just do view fans as dollar signs and as some burden they have to endure. Oh gosh, these people are going to come visit me. Vic is a guy who really appreciates each and every person who takes time out of their day to come see him. So that's a really great opportunity to go meet him and show him that you support him, and show conventions as well. This is the trick, right? The conventions are playing all of this cool, but know that they are watching all of this, and every single ounce of support that Vic gets, whether it's at a convention, whether it's on Twitter, whether it's in person, especially if people are paying to see him, going out of their way to go see him. All of those things, conventions look at that and they go, oh my God, we either need to make the business decision to bring him to our convention, or they go, we've made a terrible mistake in removing him based on these half-assed charges that have been brought against him. So really important to go see him if it's within your means, if you're a fan, or if you support him for whatever other reason. You know, I'd never ask anybody to go outside of their means to go see him, but if it's within your means and within your ability, and you like him, go support him, because it sends a huge message to all of these places. So Raleigh is the same company as Florida SuperCon, Soy Boys. Maybe someday I need to talk about Raleigh and the Florida SuperCon. Maybe someday I need to talk about those. I haven't really talked about those too much, but maybe someday I should. I'll have to consult with some people and see if I can release some information about Raleigh and Florida SuperCon at some point. But I don't know, because I do have information about those conventions. But you know, we'd like to see what happens here. Anyway, yeah, okay. Let's see. Where is... I'm going to give you guys just a little bit of cancer. Sorry. Let's do this, and then I will I'll do there's just a couple Twitter things. Okay? Yeah, here we go. Can you guys see this? I'll have to make it a little bigger. All right. This stars one of my favorite idiots, Shane Holmberg. A truly, truly, exceptionally moronic person. A connoisseur of moronity. Okay? Shane Holmberg, consistently wrong. But let's get his hot takes on this situation. Shane is loving this because he's got 21 likes, which is about 21 more than he's ever gotten in his life. But here we go. And I apologize, but if you do incur mesothelioma from this stream, you may be entitled to financial compensation, and you can seek your redress against Shane Holmberg and the other people here. Again, this will be a literal who's who of idiocy. Okay. Shane Holmberg says a con that seriously had the fans at heart was made the public scorn of YouTubers and spent weeks, if not months, with harassment from both sides. He's talking about KamehamehaCon, and he's lying pretty heavily about public scorn from YouTubers. KamehamehaCon did not get public scorn from YouTubers. Not from YouTubers on Vic's side, at least. We were either silent about it when we knew what was kind of going on behind the scenes, or when we finally did speak out about KamehamehaCon specifically, we were not negative. We were supportive. Very, very supportive. And I can confirm from the KamehamehaCon owners that support helped them with the decision to bring Vic back. The support, because they expected the negativity they were getting from the fat whales on the other side. They expected the negativity they were getting from idiots like Shane Holmberg and stuff like that, from Monica Rial, from Ron Toye, from all these people telling them that they were monsters for daring to consider upholding their contract. They were getting negativity from them for weeks. From YouTube, it was a matter of days, and it was positivity. So very, very stupid. From the start, it was a horrible no-win situation. No, it was very much a win situation, and they picked the winning situation. This is, again, completely wrong and disingenuous. The dumb thing is Shane probably knows it's wrong, or he has reason to know it's wrong. If he doesn't, it's only his own abject stupidity that prevents him from knowing it's wrong. KamehamehaCon had increased sales from the moment they re-announced Vic Mignogna. They had increased sales, they voice actors. KamehamehaCon had a better convention after re-inviting Vic than they did before re-inviting Vic. It was not a no-win situation. It was absolutely one way to win, and they picked it. You're a liar, Shane Holmberg, and you're stupid. You can't run a community show when the community is at war with itself. The community isn't at war with itself. This is one of the biggest lies going on. If you listen to people like me, Hirohe, Tug, Yellow Flash, will tell you it's a small percentage of people who are aware of the drama going on. Most anime fans have no idea. They're going to a convention. If you think about this, our shows get, like my streams on this get 50,000, 60,000, sometimes 80,000 total views when we're talking about conventions and Vic Mignogna, right? 50 to 80,000 people watch it. That's across the entire earth. And some repeats, right? 50 to 80,000. Some of this con attendance is 10, 12, 20, 30,000 people at these conventions. We're not talking about 30,000 people that are going to one convention in Texas are 30,000 people watching my show, or Tugs, or Hero Haze, or Yellow Flash. There's no way. The metrics don't pan out that way because we have a global platform and we're talking about a specifically limited geographic community. They're drawing 30,000 mostly local people to a show like KamehamehaCon. There is no way you can purport that the community is at war with itself. The numbers don't add up. Likely, you've got about a 10, to maybe 20% of the community that's aware of the internet version of the drama. Shane doesn't know how to do basic math. He knows when he cuts a shoe in half, he has 2 meals, but he couldn't tell you that combining those 2 meals makes 1 shoe. Okay? So I got to give him a pass on this. RJ says, didn't Nick time and again say to be supportive of Kamehacon and in fact tweeted them words of support? I did. Lorna Dane, his false platitudes, they weren't false. Not at all. And I still support Kamehacon. I still support the owners of it. Mean nothing when he cherry picks the text to show people to try and make it seem like Ron blackmailed and threatened them. I didn't cherry pick those texts, actually. That was the entire thread. It was in context. These dummies are so stupid that they didn't actually check what texts I sent out. So when Shane proves I cherry picked them, he picked the exact same text that I released, except from Ron Toye. Thank you, Shane, for authenticating them, for pretty much defeating their anti-slap motion by making a prima facie case for tortious interference, for eliminating the controversy that the text might have been faked or procured in some ill-gotten way or something like that. You've authenticated them. Thank you. It's great of you to do that. It was very, very helpful, and I'm happy you did it. I'm happy you were too stupid to check which tweets I actually released, because I went ahead and released all of them, the same ones you did. How embarrassing for you. Lorna Dane can't read, much less reason, so I'm not really concerned about her opinion here, but just ridiculous. I'm commenting on the statement of Shane saying Kamehacon was the object of scorn for weeks. That didn't come from Nick, nor did Nick encourage it. In fact, he did the opposite. However, didn't Ren harass Kamehacon about a refund that she wasn't entitled to? Yes. And she made a public spectacle of it and called them out and called them nasty things. I call BS. Nick was directly part of the situation which led to this. Yes, the positive part. Personally seen others discuss how Kamehacon was getting the worst of it, and most of that was because Nick was bashing everything on his show. Sure. That was me, right? That was me, not the idiot saying, how dare you invite Vic? Not Ron Toye saying he was going to get criminal charges. It was me, though. It was me. You're right. That must have been. And then this guy, Glenn NG. Thank you, Glenn. Nick Rekieta has been the chief ringleader in directing, inciting, and inflaming the harassment campaign being waged against anyone who dares criticize St. Vic. I do so by over and over saying, don't ever talk to these people. Don't engage them. Don't listen to them. They're just morons. They're not worth your time. They'll just block you. That's how I incite and engage in harassment, apparently, by saying, just ignore them. I hold him personally accountable. Good thing your opinion means nothing. For every bit of harassment carried out by Vic supporters, he made his bed here. I have never made a bed in my life. How dare you accuse me of that? Except requesting proof isn't harassment. Good point, Megami. Nick is not requesting proof. No, I am. Over and over, repeatedly and constantly requesting proof. Please, 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 for once, just prove one allegation. Anything. I'm over and over requesting it. He's leading an outrage factory for subscribers. No, not at all. I'm demanding that you just put up the text you say you have, but you don't have them. Name the people that you say are coming forward, but you can't name them. Put out the situations that you say definitely exist. Name the cons who banned him. Do anything that you said has happened, and you won't do one of them. Not one. Shane's just sitting there sucking the leather off of his chair. He can't bother to do anything he's actually stated. He badmouths anyone who dislikes Vic that leads to his subscribers attacking them. No, I don't. There are a bunch of people that dislike Vic that I haven't talked about at all. Because why would I? I talk about how stupid you are, and then people come and point it out to you. Maybe try not being mentally incapable of opening a jar of beans or whatever. Do beans come in jars? Probably in England. Let's see. Glenn, Nick is a pathetic piece of poop. How dare he use profanity? Weaponizing impotent weeb outrage. Is it impotent? Is it impotent? That's the real funny thing, right? It's impotent, yet constantly you're complaining about how effective my harassment campaign has been while simultaneously calling it impotent. Which one is it? Which one is it? Your wife doesn't think you're both impotent and effective. I'm pretty sure my harassment campaign can't be both impotent and effective either, Glenn. Wife? Is that might be presumptuous. Dog? Waifu pillow? I don't know. I don't know what Glenn does. To scrape out a few subs for his embarrassing as F streams. They're very embarrassing for somebody. For someone. No, that's what Monica is. She's no victim, just a liar. Calling her a liar without actual proof of her lying is defamation. Well, no, it isn't, actually. A liar is an opinion statement, not a statement of fact, Shane. So, good try. Someone calling someone a fraudster, calling someone a grifter, could be defamatory. Saying that they're lying in their profession, that could be defamatory. But just saying someone generally is a liar is a statement of opinion, not a statement of fact. It's non-actionable. Get over it. Show proof of Vic's action. You just called her a liar. Prove it. God. You didn't think so. Yep, didn't think so. Y'all attacked Vic with no proof. And now he's suing. It's her own fault. You're attacking someone with no proof, though. No, mountains of proof. Doesn't that make you a total effing hypocrite? No. I'm attacking someone who have lied and almost destroyed a man's life with no evidence and denied him his right to due process. He hasn't been denied anything. Well, except a job and attendance at conventions, which leads to revenue on both fronts. Also his reputation. Only those things, though. His employers investigated the claims and clearly found enough evidence to drop him. Watch this, y'all. Here's what I can suggest. One of two things is going to occur with Funimation and Rooster Teeth if Rooster Teeth is sued. If Funimation settles, their settlement will state likely that their investigation found no instances of sexual misconduct or harassment. That's what their statement on settlement will be. Okay? It has to be. It has to be probably as provision of the settlement. Otherwise, what are you settling for? 2, if they don't settle, watch. I promise you that this is going to happen because it's the only logical way to do this. The defense from Funimation will state that their statement on Twitter relating to the investigation is misread because their statement does not say that Vic was fired as the result of an investigation, only following an investigation, and that those two are separate factual statements that do not make a defamatory allegation. I promise you that will be in Funimation. I shouldn't promise. If I were writing Funimation's defense with the information that I have, which is pretty significant, I would clearly state that it does not say in the tweet, and I would actually blame the medium of Twitter for my inability to clarify that within the 280 character limit. These are subsequent statements, and the statement against harassment that follows, they will likely argue, is a statement of the company's policy and not directly related to Vic Mignogna. Now, a reasonable person, do they buy Funimation's argument? That's a different question, but that will be Funimation's argument, that we did not state that we fired Vic Mignogna as the result of findings of sexual harassment or sexual assault. I promise you that's in their answer. I gotta stop saying I promise you, because I'll definitely be wrong if I do it. But that is almost guaranteed. It's almost guaranteed to be part of their answer, because it would, if they win on that fact, they defeat defamation. Of course they're gonna make that argument. Glenn, Shane, Ron, Monica, these people are too stupid to understand that Funimation doesn't owe them the satisfaction of making that statement. Funimation only owes it to itself to extricate itself from this lawsuit as fast as possible, either by settlement or by flat out defending it on the basis that that statement is not defamatory because it does not directly accuse Vic Mignogna of sexual harassment or assault. Period. Period, period, period. This whole employers, they didn't say that. That's what you read. And that's the argument against Funimation, is everyone read it how Glenn read it, but the lawyer's going to argue the opposite. And the fact that these people can't see that shows why they shouldn't be talking about it. They're too short-sighted or too stupid to understand what that argument is. And that argument is obvious to any lawyer who's looking at Funimation like, how do I defend this? Well, we've got to say that statement doesn't say what they read, that they're reading into it on purpose to bring Funimation into the lawsuit, blah, 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 blah. They've got to do that. Just because they didn't share their evidence with whining little weebs on social media doesn't mean they don't have any. No, it doesn't. But the fact that Monica, Ron, Shane, people who have notoriously and repeatedly leaked this stuff for months haven't shared it, sure indicates that they don't have it. You don't know poop about this case. Well, neither do you, Glenn. Who's Glenn? Except his employer said they were inconclusive. Monica and them attempted to destroy his life over Twitter, and now they're being sued for it. They have nobody but themselves to blame. There was nothing inconclusive about it. I mean, the IO9 article specifically says that an investigation was inconclusive from a Funimation employee who purports to have knowledge of the investigation. So, show me where it was shown the investigation was inconclusive. It was stated when the mess first started. Sorry, you can't handle facts. That's the IO9 article. They interviewed a Funimation employee who said that there was an investigation that was inconclusive. Now this person, I don't know if this is a woman or a man. They say they, them, utterly asexual, strong jawline. Not sure about it. Without Nick, the uproar would have died down as the legal process played out. It would go quiet until the actual case where all the stories could be compiled and the pub kick get a proper response of what was happening for years. He really is to blame. Thank you. Thank you. I will take that flag and wave it from the rooftops, you flipping moron. Because if there wasn't an uproar, Vic would be at less cons this year than he's going to be at. Vic's reputation would be tanked while you guys pissed on his grave. And then whatever the outcome of the legal case was, you would have so thoroughly defamed him and ruined him that he would be dead after the suit. Now, because of the uproar from his fans, and the uproar is an uproar in overwhelming and comical support of someone that you wanted to die. The uproar is overwhelming support of this guy. Showing all of these people where they will spend their money, and they will routinely put money towards where Vic is. Why on earth would we want that uproar to die down, you dummy? Absolutely stupid. Absolutely stupid. Ultimately, individual people's behavior is to blame. From what I've seen, though, Nick is the embodiment of an opportunistic parasite who's been deliberately stirring the muck to make sure he gets more subscribers and holding super chats to wring every last penny he can out. Yes, I'm wringing the super chats out of people. I'm holding them. I don't know how you hold super chats. It's a feature that's been on my channel since for a year, well over a year now. Oh my goodness. Oh, I agree. But I also feel there's a need to isolate the opportunists driving this circle versus the dumbasses who get roped in. Both are horrible, but the level of culpability of the manipulators deserves special scrutiny. Okay, whatever. But ask any of his fanboys, it's about justice, not money for Nick. I did this before any money came in. I sat through one because I don't condemn a show without watching it. It was filled with bro speak and thinly veiled alt-right propaganda, because that's what sells, apparently. I hope you alt-right are propagandized. I hope so. Let me see. Richard Spencer, Mike Cernovich, David Duke. Who else is alt-right now? Sargon. What buzzwords can I put in? What alt-right buzzwords will hypnotize and propagandize you guys? I need to do it. I need to do it. Oh my gosh. Oh my gosh. Trump, 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 Trump. Listen. There's a YouTuber out there I fully endorse. His name is Nick Rekieta. Rekieta lawsplaining interwebs, whatever. Let's build a wall around this stream. I don't know. How much more alt-right propaganda can I cram in? I have to alt-right everything. Ben Shabir. Oh, yes, the oak. Yeah, look out. Watch out. Andy Cooley, I'll laugh my butt off if that Vic legal fees thing is taken by Nick for personal use. Literally can't, never could take a penny from it. So stupid. No, it appears to be going to Ty's firm. Nick is still making a killing off the collateral, which is why he wants the circus to continue as long as he can make it. No, I want the circus to continue because I want Vic to have a career at the end of the day, and that doesn't happen from the lawsuit. It happens by paying customers, paying for Vic. That's it. That's all I've ever asked for, is for people who support Vic within their means to continue to do so, and to do so as often as possible, because every dollar to that GoFundMe is a knife in the eyeball of you idiots. Every dollar to that GoFundMe says that we will pay for nothing. We will pay for no reward. There's no signature. There's no merch. There's no visit. There's no talk. There's nothing that you get to contribute to the GoFundMe other than the satisfaction of saying, I know that this dollar makes it more possible for Vic to continue in this medium. How strong of a statement that is mind-boggling. And every person who goes to Kamehacon who wasn't gonna go, every person who flies from another country to see Vic, every story on Twitter that comes out stomps in your stupid face and says, you're an idiot, the fans want Vic, and it's over and over true, while Marky has no line, while Monica has 3 embarrassing virgins in her line, just desperately hoping she'll have another spank off so Ron can sit in the corner and watch. Every single convention that Vic goes to is lines out the flipping door, and every convention that the people you support go to doesn't know what a line is because there's like one person standing at a table, and to be fair, they walked up and thought it was a lunch lady and hoped they could pick up a tray. How embarrassing for those people that no one wants to see them. And remember, most of these people don't even know about the drama, so they just don't want to see them because they're uninteresting and they're not pleasant to behold. There's no polite way to say it. There's no polite way to say it. If I needed a short-haired alien boy model, I would go visit Monica Rial. That's it. Nick started it, and I believe he's still in charge of it. You can believe what you want, you idiot. It's flatly stated on the GoFundMe. And if you've ever run a GoFundMe, you know that when you make it on behalf of a third party, they disable immediately your ability to withdraw funds until it's verified. It's almost like they try and prevent fraud constantly. Part of their business. Daniel Fitzpatrick says, Nick is basically leading a propaganda distributing network. Look, I just have to point out, this is Daniel Fitzpatrick, okay? I have to point it out. This is where your wizened sage response is coming from. All right. Oh, I probably lost it. That's okay. That's okay. I had to find this by Nick Rekieta Ringleader in an anonymous tab because I'm blocked by all of these morons. All of these morons. So let's see. What else do we have here? Now let's go to the other one. This is the legal argument going on. Where was this? Where was this thing? Oh my God. I just updated Shane thing. 130 new tweets. Oh. Oh God. Let's see. Okay, I had this open in a tab. Let me find it. Sorry for boomer hour here. Is this it? Nope. Oh God. Let's see. I'm not going to read 130 new tweets from Shane. I would die. I would die. I don't have enough liquor on the shelf for that. Okay. I can find this. I can find this. Let's see. Nick. Oh, I responded to this, didn't I? No? Oh, wait. What is it? I can do this. Let me see. I can find this. We need the most recent one. Okay. Haha. Okay. Let's do this. I've got it. Got it. All right. Make sure that's centered before we get going here. This is why. Look, if you don't know, if you're not specifically educated on law, perfectly fine. Going to law school is like, I was going to compare it to something that's not really fair to compare it to. It's horrid. It's expensive. It's time consuming. Most people don't do it because why should you? And why in God's name would you want to surround yourself with lawyers? Ugh, they're the worst people on earth. The worst people on earth are lawyers. So there's no shame in not knowing how to read case law generally. If you don't know how to read case law and you have a case that you're trying to cite, please ask someone who does. Public service announcement. Please just ask. You know, lots of lawyers will break down a basic concept for you. There are websites that can do it. This person didn't do it. This is a public service announcement, a warning to all of you who are considering engaging in a legal discussion online. Let me warn against it. It's not safe for your health. It's not safe for anyone's well-being. But let me hit these chats real quick. Jack Dirac, thank you for donating. John Sargent says, did Rooster Teeth attempt bribery to commit TI? Or Ron Toye, attempt bribery to commit TI with Kick Vic. No, probably not. Not bribery necessarily. Maybe extortion, similar to bribery, but most likely it was really just tortious interference. Philip Trent says, what the heck is Laura Nadane talking about? You showed all of the text. What exactly was cherry picked? Buddy, she doesn't know what cherry picked means. She doesn't know what words mean. She's an idiot. An absolute abject idiot. Chris Nunez says, Shane Shoe Gourmet Holmberg is the expert in contracts, right? Maybe he can help Tenney's legal counsel. Maybe he can get them to stop their Twitter wars. And what is his deal with the attack tweets against you, then hide? He's a labia. A terrified little labia that retreats immediately when the real players show up, I guess. He's Shane, right? He's Shane. Solo Beverly says, ouch, you wrung this out of me. Bagel Goose says, ring me harder, Law Daddy. Austin Heartless says, quit ringing the super chats from me, gosh darn it. Justin Tape says, you took this super chat from my hands, as Shane said. Legend of Blue says, shut up and take my money, Nick. Octurian says, I'm still waiting for them to freak out over your very clearly alt-right flag hanging in the background. Here's to stirring the muck and taking my cash, 10 American bucks at a time. Geld Walker says, get Milo to sponsor you, Nick. You drink enough of it. I would love a Milo sponsorship, unironically. Blackened Soul says, Shane's tweets gave me cancer. Can I sue him? Gosh, what would you get out of it? What would you get out of it? You wouldn't even get a pair of Nikes. You get like a pair of British Knights from 1993. All right. All right, here we go. Okay. Yes, there is. That's a huge no-no for lawyers to do. Okay, let's go back. This is in response to some text messages from Ron Toye, right? Ron Toye to Kamehacon that I released, and I had the big reveal yesterday. Shane Holmberg says, hey, so if the con says they did not give the text to Nick and only to Ty, how did Nick get them? Well, I didn't say at first. This one set me off the other day and I didn't get to respond. I've yet to see anything saying Kamehacon said that, mind you, but for the sake of argument, Kamehacon did. There's nothing legally stopping from Ty from releasing them himself, much less giving them to Nick. This is true. And to be clear, Ty absolutely gave me those texts. Absolutely, Ty gave me those texts. And once I had those texts, I was happy to go ahead and decide to release them to the public. Because those texts cleared me when all of these dummies were calling me a liar and saying I could never prove what I said about Ron tortiously interfering with Kamehacon and Monica tortiously interfering with Kamehacon and other cons. They said I could never prove it, that I was wrong, that I was lying, that I was grifting, that I was promoting outrage, all of the same stuff. And I did it in one shot. One no scope, 360 headshot, whatever it is. Absolutely annihilated their literally defamatory claims against me, right? Because they knew that these texts existed. They knew that they existed, but they swore to God that they didn't happen. They swore over and over that they did not occur. And then I posted them. They defamed me for about a month. And then I posted them. Stop defaming me. Because I can prove it, you idiots. So anyway, but it doesn't matter that I got them from Ty, and I absolutely did and had no hesitation releasing them because they cleared my name from liars who lie constantly, spreading lies about me. So that was their bad. That was their bad. Anyway. Not saying that is what happened, not saying it isn't. Well, it was. It was. But you mean to tell me a lawyer for the plaintiff would have demanded private texts from a con? Texts aren't private. Texts are not private. Texts are verified, recorded statements sent from one party to another. They fall outside of the wiretapping laws. You have no expectation of privacy in a text. And by the way, you give the content of that text message to your cell phone carrier. You idiot. There's no privacy there. Shane, you are stupid. Over and over and over again. It can't be said enough. You're absolutely stupid. And you're ignorant about what the law is, but you're stupid, Shane. Shane, get help. Get hooked on phonics or whatever. You need some sort of extracurricular activity to bring you up to the same speed as everyone else. Your texts are not private. You have no privacy interest in them. When you give them to someone else, they can do whatever they want with them. They can broadcast them to the world. You may think it's rude, but they can do it. They can absolutely do it. So stop calling them things that they aren't. They're just texts. They're not private. There's no thing that says we have a confidentiality agreement. They didn't have the contract. That's part of the problem, is that they were interfering with someone else's contract to try, or they were trying to hold out a contract potential to interfere with someone else's. Because I can pretty much guarantee you that $25,000 coming into Kamehacon was likely more than Kamehakon's promise to pay Vic on his minimum. And they probably knew that they wouldn't have to pay Vic a dime. But even if all of this stuff proved out true, Vic was slandered and showed up and no one showed up and Kamehacon had to pay out the full amount to Vic, the $25,000 promised by Ron and the Tuttle Group would be worth more than whatever they would have to lose paying out to Vic. There's huge incentive for them to consider a $25,000 guaranteed payment versus a gamble on someone whose reputation is in the dirt. Absolutely tortious interference. And then intentionally release them to someone he knew was going to publish them and attempt to defame and harass a defendant. No defamation there. Those are Ron's words in context, clearly leading to the conclusion of tortious interference and defamation of character of Vic Mignogna. Absolutely. I haven't said anything defamatory about Ron. I've said Ron's stupid and Ron's a cuck and all that stuff, but I'm pretty sure that's true. It's also jokes and ridicule, which is protected First Amendment speech and not defamatory. I've never lied about Ron Toye or Monica Rial. Even if he did, there's nothing illegal about it. And while the texts were defamatory, they weren't defamatory. Well, I mean, they're defamatory in the non-legal sense. Okay, so there's the Webster's definition of defamatory, which says that something is defamatory if it brings disrepute upon someone. And then there's the legal definition, which is it brings disrepute and is false. That's a big difference from the other one, because calling a pedophile ruins their reputation and is technically under the colloquial use defamatory, but it's not legally defamatory because it's not a lie, right? Dave Mark says, what about the Tuttle Group? Do they have skin in this? They might. It depends on if Ron is actually acting as their agent and they're endorsing that activity or not. It'll be really interesting to see what discovery comes out of the Tuttle Group. As far as harassment, where is that? I've not seen Nick Rekieta harass defendants. Don't harass them. I don't. When they engage in my Twitter posts, I may retweet them and talk to them. That's Twitter. Harassing is an intent to annoy. I'm not trying to annoy them in any way. I'm trying to make their presence on social media laughable. Absolutely. Yes, there is. There's a huge no-no for lawyers to do. Enter me, because I finally see this. What's a huge no-no? Purposefully releasing evidence in an ongoing investigation. Notice, immediately this guy goes the law and order route. He's talking about criminal procedure. You can read it in the text. For the sole purpose of defaming a defendant, he's talking about a criminal defendant. This actually would be improper for a prosecutor to do. Wildly different than civil plaintiffs. If the client does that, I don't know. It's fine. Let me help you. It's absolutely flipping fine. but I know that a lawyer doing that is not allowed. Not true. Not true, you idiot. Let's see. 4 lawyers are wrong about it being a really strong case for TI. Yeah, because I did do the 4 lawyer stream. We talked about these. Not talking about a case for TI at the moment, just the act of giving the text to Nick. Yeah, like I said, if it can be proven they gave those texts to Nick, they did. There's your proof. Now try and do something about it. Try it. The case can get dismissed pretty soon. Wrong? No, it can't. What weird legal system do you live in? Yeah, it can. If not dismissed, then at least a mistrial can be declared. Williamson versus United States. By the way, if you're not aware, generally speaking, you cannot sue a city, a state, a federal government. You have to sue someone in their capacity as a representative of whatever governmental organization you have, because the United States has sovereign immunity from lawsuits. So you can't sue the US. They're not a named party. You would sue someone in the United States for infringing upon your rights under like a 1983, under Section 1983, which is a deprivation of your rights under the color of law. For example, like you might sue the Attorney General. You might sue the chief prosecutor of the FBI. You would not sue the United States. If it's Williamson versus United States, this is just a pro tip that 1994 means it's a Supreme Court citation. If it was a lower court, the lower court would be listed in the parenthetical. Like if it was the 9th Circuit Court of Appeals, it would say 9th Circuit Court Appeals, 1994. Just saying 1994 means Supreme Court of the United States. There's a Supreme Court decision with the appellant being Williamson versus United States. The implication on the face of this, even before you even look it up, is that this is a criminal case in federal court. The federal court found this guy guilty of a federal crime, and he has appealed it up to the Supreme Court. If you're not a lawyer, you might not know how to read that citation in that way. That's the first problem with talking about a case specifically online in a definitive rather than an inquisitive manner. This guy is stating openly that this is a citation for dismissing via releasing text in a civil case by the plaintiff's attorney. Okay. If the judge determines that grave misconduct was committed by the attorney for leaking text, then the judge is within his rights to declare a mistrial. Technically, I guess that's kind of correct, except that would be appealed and overturned in a heartbeat unless there was a protective order on those text messages. Now, let's go to the case, because I pulled it up. Williamson versus United States. And we're not going to read through this case. It's kind of long, and its opinion was written by Sandra Day O'Connor in 1994. Here we go. This is just to give you an idea of what this person cited. In their it's so stupid. I'm trying to get my chat window back. I'm sorry. It's so stupid. Okay. Mr. Reginald Harris refused to testify at petitioner Williamson's federal trial on cocaine possession and distribution charges. The district court ruled that under Federal Rule of Evidence 804b3's hearsay exception for statements against penal interest, a DEA agent could recount 2 custodial interviews in which Harris had freely confessed to receiving and transporting the drugs in question, but also implicated Williamson as the drug's owner. Williamson was eventually convicted, and the Court of Appeals confirmed. This gets a little bit heavy on the law. I'm going to walk you through it in the most efficient way possible, okay? I'm not going to do a bunch of rule citing. I'll talk about 804b3 specifically. It's a very specific exception, and I can just tell you what happened. So, Williamson, the subject of this case, was convicted for possession of cocaine by the United States government in a federal crime, okay? Harris was a co-defendant or a witness that the federal government wanted to testify against Williamson. They said, look, you've talked to us in interviews and said that you got cocaine from Williamson. We want you to come in and testify that Williamson had the cocaine. All right? He said, nah, bro, I'm cool. I'm not going to do that. So instead, so here's the next thing they do. They want the DEA agent who interviewed Harris to make a statement about what Harris said in that interview. All right, you're with me now. So the DEA agent is going to use Harris's statement to implicate Williamson. This is hearsay because Harris should talk about what Harris said, not a DEA agent should talk about what Harris said. That's hearsay. That is outside of the federal rules of evidence unless it falls within a very specific exception. Federal Rule of Evidence 804B3 is a hearsay exception that says if a party is unavailable to provide a statement, or if a witness is unavailable to provide a statement, a verified statement of what the witness said could be used to supplement it. But the person has to have a reason to be unavailable, like they're dead, they're in a coma, they're in Beirut, right? They're deployed in the military and bringing them back would be onerous, if not impossible. They're special forces. No one knows where they are. They're a gimp in a cuck dungeon and no one can find them. These are reasons why someone is unaccessible. Harris simply saying, nah, bro, I don't want to go into court and state that I got cocaine from someone because I think that might get me in trouble, right? That is not sufficient grounds for an 804B3 exception because Harris can make the statement. And if Harris won't make the statement, you've got an uncooperative witness. There are ways to compel them to speak. You can do that. Instead, they use the DEA agent to attest to what Harris said. Here's what he said before. That proves this thing now. Nope. Hearsay, inadmissible, overly prejudicial to the defendant. Can't do it. Can't do it. This is a completely and utterly different thing than a plaintiff's attorney in a civil case releasing text messages to the public. The rule isn't on point. It's not hearsay. It's nothing. There's nothing to do with what happened in this case with what happened in Vic's case. It is the worst possible citation you could use. There are no text messages. There's no third-party communication that was released publicly. It's not about a public release. In Vic's case, there's no hearsay because they're verified by Ron Toye. They're a party statement, and any party statement can be used against the party so long as that party statement can be authenticated. He did it on Twitter. Everything about this is wrong. He couldn't have been more wrong. He's absolutely stupid on how he approached this. And all he had to do is, instead of saying it was like this, just ask, wait a minute, what does this case say? And I would have politely answered, actually, that's on Rule 804B3. It's completely different than the rule you're looking for. This is not the rule you're looking for. And it's not really a case on point. Here's why, blah, 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 blah. I probably would have made a stupidly long Twitter thread about it. But no. This guy is saying we're engaging in malpractice, misconduct, dismissible by a sanction, apparently. Sanctionable conduct. No, absolutely not. Absolutely not. These people said they want every single thing to be public, so it was made public. And now these cowards are hiding behind, well, we want everything to be made public, but we want to do it right. Yeah. You pussies, put it out there. Put it out there. You won't because you're scared or because you don't have anything. And that's what everybody watching this case knows. Ron Toye and Monica Rial have nothing. They have nothing. They've been hyping the investigation. That thing's going to deflate real quick. Real quick. They've got nothing. And how embarrassing for Ron Toye to come out and say, well, I actually don't know about the investigation. That I told Kamea-Con was his big thing. I don't know anything about the event. I just knew that one was going on. How embarrassing for you, Ron. What a pathetic cuck walk you had to take. Oh my goodness. Goodness gracious. All right. Okay, so that's why don't work for the law firm of Twit and Don't do it. It's terrible. You're subject to ridicule. It's part of your contract. Don't do it. Don't do it. All right, so this is the brief petition from the labor commissioner, or before the labor commissioner, Turner Tenney, again, Tenney or Tfue versus Faze Clan Incorporated. Petition to determine controversy. Petition is filed pursuant to to the authority of Section 1744 of the Labor Code of California. Tenney alleges the following. Tenney, professionally known as Tfue, is a 21-year-old gamer and content creator, performs and creates videos featured on online platforms which have become increasingly popular and in turn lucrative. Because Tenney's videos are viewed by millions, sponsors are willing to pay him to create videos in part, or that will at least in part promote their goods, services, or brands. Faze Clan is so-called eSports entertainment company. Business model is illegal and designed to take advantage of and exploit young artists. To make matters worse, knowingly, if not intentionally, subjects these young artists to derelict and even dangerous conditions. Kind of like what Shane talked about at conventions that he used to work at 20 years ago. Faze Clan, which is not a licensed talent agency, exploits young artists like Tenney through oppressive and predatory long-term contracts whereby Faze Clan essentially owns the artist and the artist's career. Under Faze Clan's illegal gamer agreements, Faze Clan secures the purported right to procure employment or engagement for the young artists like Tenney. To that end, Faze Clan's primary and essential function is to promote and sell Tenney's artistic services and procure sponsorship deals which feature those services. That is, sponsors pay for Tenney to perform in and create online content and or to model apparel featuring the sponsor's brands. Faze Clan then retains a grossly unconscionable commission for sourcing the deal, up to 80%. To add insult to injury, Faze Clan uses gamer agreement to prevent Tenney from procuring or negotiating such employment opportunities without Faze Clan, and prevents Tenney from using the services of a legitimate and licensed talent agency. Let's see. Faze Clan's continuous and systematic procurement and attempted procurement of employment and engagements for Tenney as an artist is illegal and is a brazen violation of California's Talent Agency Act, particularly Labor Code 1700.5, which protects artists from those like Faze Clan that act as an unlicensed talent agency. Because Faze Clan has illegally procured and attempted to procure employment engagements without the required license from the California Labor Commissioner, gamer agreement should be deemed void and unenforceable. Likewise, Faze Clan must disgorge all commissions, monies, or other consideration that it has retained under the gamer agreement. Materion says, heresy against the law? Does that exist? And if so, can we pin that on Shane? Shane is a heresy against life. Shane is a heresy against life and everything in it. Because Faze Clan is unlicensed, it has avoided regulation by California's Labor Commissioner. The need for licensure and regulation, however, is dire. Not only does Faze Clan take advantage of these young artists, it jeopardizes their health, safety, and welfare in violation of the Talent Agency Act, and particularly Labor Code 1733, 34, 35, and 36. Faze Clan pressures and encourages young artists like Tenney to perform dangerous stunts. In one instance, Tenney suffered an injury, a deep wound that likely required stitches. That's a weird way to put that. That's a weird way to put that. That indicates to me that he didn't get stitches. Likely required stitches, which resulted in permanent disfigurement. So since he didn't get stitches, I guess he got a big scar. And a scar is permanent disfigurement. make no mistake, under the law, well, at least in my state and presumably in California, any permanent scarring is considered a permanent disfigurement, and a person who does so because of another party's actions. And Faze House, that would encourage other young artists to perform dangerous and derelict activities. Petition to determine controversy will not only relieve Tenney from the illegal and oppressive gamer agreement, but will hopefully send a message to Faze Clan and prevent it from continuing to illegally profit from and take advantage of other young artists. Faze Clan's illegal and dangerous business model must end. So there's a Faze House. Faze Clan talent live. So wait. Oh, that's why Mithra and Imris must have been saying that if they provide compensation, potentially are providing compensation but deducting living expenses from it. Oh my God, that better be clearly spelled out in the contract, or else they're going to get absolutely annihilated. Because it would certainly be within Faze Clan's interest to have its talent living in the same house, because they can exploit it as a business opportunity. So then to say that they're entitled to compensation absent an explicit agreement, they'd be crucified in court. Wow. Factual allegations. Tenney is residing in Los Angeles, California, and Indian Rocks Beach, Florida. Individual who is an artist, as that term is defined by Labor Code 1704B. Tenney both creates and performs an audio, video, motion picture content that is featured on popular online platforms such as YouTube, Twitch, Instagram, and elsewhere. Performance in and creation of such videos is the primary source of his economic value, especially to the millions who view videos that feature Tenney's performances. Notably, Tenney's YouTube channel, which streams videos created by Tenney and featuring Tenney's performances, has grown to over 10 million subscribers. Holy cats. He's also modeled and promoted brands on his Instagram channel. Upon information and belief, Faze Clan is a Delaware corporation, principal place of business in LA. An eSports entertainment company. Upon information and belief, they have never held a valid license to act as a talent agency in California where it conducts business. At all times mentioned herein, they've acted in the capacity of an unlicensed talent agency. In or around April or May 2018, Faze Clan and Tenney entered into a certain written gamer agreement with the effective date of April 27th. Gamer agreement was entered into in California. Tenney was only 20 at the time. Gamer agreement had an initial term of 6 months and would automatically be extended for an additional 36 months if certain conditions were met. On or about September 26, 2018, Tenney provided written notice of his intent to terminate the gamer agreement for cause. Faze Clan, however, disputed Tenney's termination of the gamer agreement for cause. May, June, July, August, September. That's only 5 months in. So he had a month left on his initial 6-month term. Based on the express terms of the agreement, Faze Clan was tasked with procuring and attempting to procure employment or engagements featuring Tenney as an artist. Under the section of the gamer agreement entitled compensation, Faze Clan was entitled to an unconscionable 80% commission for certain employment engagements procured by Faze Clan. Specifically, the gamer agreement states in pertinent part as follows. This is terrifying. Brand deals featuring the gamer that exist on gamer or company's content creation platforms, e.g. Twitch or YouTube, or social media sites, if the deal is brought to gamer by company, 20% to gamer and 80% to company. Now, remember, their agreement also gives them effective veto power through the negotiation, through like a required negotiation clause of any third party sponsorship. Because like, let's say they have a different agreement, like 20% if he brings it in, but they have negotiation power over that partner under the terms we read above, which means that person comes in, they're like, well, we won't do it for less than $10 million. They just throw out a ridiculous amount to get them to say no. Well, then they've effectively vetoed it by refusing to negotiate in good faith and fair dealing and with a fiduciary duty to Tenney. So they can effectively exclude any third-party sponsorships that Tenney brings in and only allow ones that they bring in, thereby securing a monopoly on that 80% commission. That is absolutely unconscionable. That is 100% unconscionable. And if that's true, they'll burn over this. They'll burn bad. Moreover, Section 5A of the Gamer Agreement purports to require Tenney to submit all sponsorship opportunities to Faze Clan so that Faze Clan can, quote, oh, here it comes, negotiate the terms and conditions of any such opportunities, and, quote, company will also work to source sponsorship and or endorsement opportunities on behalf of Gamer. Emphasis added. The Gamer Agreement also requires Tenney to pay Faze Clan a 50% commission on Tenney's appearances, touring, and similar activities. 50%? Oh my God, why did you sign this? Since their gamer agreement was entered into, Faze Clan has acted as Tenney's unlicensed California talent agency in violation of the labor code. They've continuously and systematically procured and attempted to procure employment and or engagements for Tenney as an artist, doing so as Faze Clan's central purpose. Since the inception of the gamer agreement, Faze Clan actively participated in the procurement and negotiation of sponsorship deals, which included Tenney's service as an artist. Faze Clan frequently and continuously presented such sponsorship opportunities to Tenney. Under these proposed deals, procured by Faze Clan, sponsors would agree to pay money so that their brands, goods, and their services would be promoted in connection with videos featuring Tenney's performances and created by Tenney. Stated differently, Tenney would perform creative services, performing in and creating video content in connection with these sponsorship deals. By way of example, only Tenney created and performed a video for sponsored Digital Storm promoting Digital Storm's products that garnered over 19 million views. That's a lot of YouTube revenue. If it's on YouTube, that is a absolute fortune in ad revenue. I don't even know what that would look like, but I can estimate that it's let's see. Sheesh. We'll say it's $1,500 per million views. Multiply that by 19. That's a lot of money for one video. That's a lot of money. Faze Clan has also procured and attempted to procure modeling engagements for Tenney, where he would model apparel and jewelry for certain sponsors. Furthermore, on any deal or potential deal for Tenney's services as an artist, Faze Clan has insisted that it negotiate such a deal. That's under the contract. Upon information and belief, Faze Clan has received payment of funds on Tenney's behalf from third parties under the sponsorship deals that included Tenney's services as an artist. Over the past year, Faze Clan retained at least a portion of those payments as a commission under the gamer agreement. Faze Clan has also violated Labor Code 33, 34, 35, and 36. Moved Tenney to Los Angeles, California, and pressured him to live in one of Faze Clan's homes in the Hollywood Hills with other young YouTubers on Faze Clan's roster. Faze Clan would frequently host parties at its Cloud House or Faze House, which were fueled by alcohol, even though Tenney was underage until he turned 21 in January 2019. Let me tell you what you don't want. You don't ever want to have given liquor to a minor and have them within a year say, these guys gave me liquor and I was a minor and they knew it. Oh my goodness, you don't want that. You don't want that at all. That plays poorly in civil court and may carry severe criminal investigations. Faze Clan would furnish and encourage Tenney to consume alcohol. Additionally, Faze Clan, and he's under 21. He can't consent to consuming alcohol. Oh my goodness. Additionally, Faze Clan would encourage Tenney and others to illegally gamble at the Cloud House or Faze House. I don't know if that's true. Illegal gambling has a very specific definition usually in the States, and without laying out the specific activity, I'm less willing to give credence to this claim because private bets aren't necessarily illegal gambling. So I don't know what they're doing. Such conduct by Faze Clan was in violation of Labor Code 34 and 35. Continuously pressured and encouraged Tenney and others to undertake dangerous stunts while performing videos. During one video, Tenney suffered an injury to his arm while skateboarding, which resulted in permanent disfigurement. Following his injury, Faze Clan did not even seek appropriate medical attention. During another video, Tenney was hit by a car while skateboarding. Such conduct by Faze Clan was in violation of Labor Code 33. Hope they got specific liability waivers for the activities that they were doing, and they better be specific to the injuries that could arise from skateboarding and getting struck by a car. Otherwise, that's a problem. There's also why those are still within the statute of limitations, y'all. That's interesting. He could actually sue them for and hold them liable for any injuries he suffered. And in California, you get to claim pain and suffering. Minnesota, you don't really get to claim pain and suffering. So that could be a monumental judgment against him. Especially if looking at a skateboard is traumatizing from now on. And he's in therapy for it. It's widely publicized that Faze Clan has recently signed an 11-year-old gamer artist. Upon information and belief, Faze Clan has not only lied about the minor's age, but has also pressured the minor and his family to do so. Such conduct by Faze Clan was in violation of Labor Code 36. Actual controversy has arisen and now exists between Tenney and Faze Clan. Consequently, Tenney submits this matter for resolution by the Labor Commissioner, reserving any and all legal and equitable rights against Faze Clan, which are not within the jurisdiction of the Labor Commissioner. Tenney respectfully requests a hearing on this petition in LA. Declaration that, so they're asking for a determination that Faze Clan has violated the Labor Code by procuring and or attempting to procure employment and or engagements for Tenney as an artist. Determination the gamer agreement is void ab initio and unenforceable. That Tenney owes no further monies to Faze Clan under the gamer agreement. Termination that Faze Clan is not permitted to continue to act as Tenney's talent agency. That Faze Clan is not permitted to procure or attempt to procure employment or engagement for Tenney as an artist. And that Faze Clan is not permitted to continue to negotiate the terms of any employment or engagements for Tenney as an artist. Termination that Faze Clan is not entitled to and cannot retain any portion of monies paid by third parties in connection with Tenney's artistic services based on the gamer agreement, which is void ab initio and unenforceable. Order requiring Faze Clan to disgorge and repay Tenney any and all monies, consideration, or things of value received by Faze Clan directly or indirectly as a result of the gamer agreement, including without limitation any and all commissions, fees, profits, advances, plus interest thereon at the rate of 10% that says then, but 10% per annum. And accounting by Faze Clan to Tenney of all monies in consideration or things of value received by Faze Clan directly or indirectly as a result of the gamer agreement, including without limitation any and all commissions, fees, profits, and advances. Now, Faze Clan has said that they've paid him $60,000 or only collected $60,000 or whatever. They're going to have to back that up. And then Tenney will have the opportunity to say that every sponsorship that he did was worth more, and he'll have the opportunity to depose the sponsors and suggest that and ask them what the real number was. Faze Clan's accounting better be 100% on point on this, or they're going to get just raked over every coal you can imagine. And then finally, an order permanently enjoining Faze Clan and anyone acting in concert with Faze Clan from continuing to violate the Labor Code and such other relief that the commissioner may deem just and proper. So there you go, guys. Big claims from Tenney. Big claims from Tfue against Faze Clan. And big if true, so to speak. And seemingly well-reasoned. The petitions are relatively well-drafted. The second petition is phenomenal. The first petition has a couple problems with stating things are overtly illegal. They can be cured upon an amended complaint. I don't think it's possible they could be dismissed outright as legal conclusions, but even though the legal conclusions are there, the underlying facts do seem to back up those legal conclusions. So they should be able to get to those causes of action anyway. They might just get a little bit griped at by the judge on it. But there you go. There you go. Interesting suit. I'll be monitoring it. I'll hopefully be providing the answer document when it comes out, or the motion to dismiss, whichever one they try to go with. They might do both concurrently, but massively interesting case here. And we're going to see more of this. We're going to see more of this. eSports, this guy's got 10 million subscribers. His channel makes a ton of money. Clearly, he would make a ton of money and be able to afford a lawyer, high caliber lawyer, to fight this. It would become worth it for him, especially if they're taking his sponsorship deals or preventing him from getting sponsorship deals. This is real money. This is real money. This is NFL money. Absolutely. If this guy's got a channel that big, he's making maybe into seven figures, maybe, significant amounts of seven figures. Yeah, there's, I don't know how many videos he does. I guess I could check his social blade, right? Let me see what his channel is called. It's just Tfue. Okay. Hold on. Let me take a peek at this thing. Yeah, 10 million subscribers. Tfue, let me take his social blade and see what his views are. I'm sure they're massive. I just don't know. Come on. Million views a day. A day. This guy averages 2 million views. So, if we go ahead and what? It's $3,000 a day, right? Is a rough calculation on views and ads. And that's just ad revenue. I'm not talking about live streams. I'm not talking about anything else. Every day of the year that goes by, every day of the year, this guy earns $3,000. Right now. 3,000 times 365, no holidays. That's $1,095,000 in ad revenue alone. Alone. That's not including super chats. That's not including Streamlabs donations. That's not including Patreon. That's not including merchandise. It's not including Twitch. It's not including ad specific promotions. That's just $1 million right there for that guy. Whew. This is real money. It's real money. And that's why we're going to see more of these things coming out. The reason you don't see lawsuits in places like anime, you don't see lawsuits in the tabletop role-playing game industry. You don't see lawsuits coming out of comics. Who makes this kind of money? You got to make this kind of money to hire counsel to really take on some of these cases. As these people keep going. I mean, wow. That's as they keep making money, as esports keeps getting bigger, we're going to see lawsuits like this. There'll be people with money to come against these people. So, there you go. Watch Faze Bank's YouTube video. I will. I anxiously await Faze Bank's legal response as well. Very interested. And if a representative of Faze Banks wants to come on this show and talk about this case, since they are talking about it publicly, I would love to host them. I don't know, these are just allegations and a complaint. So if Faze Banks wants to send an ambassador to talk on this show to address a lawsuit, 1,000,000% happy to host them live. I think we'd get a very big audience. Lots of questions about it. They could certainly make their case. Of course, they'll make their case in the answer, and I will cover that as well. And again, not that someone with a channel like Tfue would see this or be would be wanting to, but if he were willing to come on the show and talk about it, I would love to host him as well and get his side of the story. Like I said, I don't know anything about this stuff. Very, very interested to see how it works out, because esports will be shaped by this case in some way or another. And esports is an emerging market. So, and one that I'm personally invested in. So I really do want to see what happens with it. All right, guys. All right. That's the show for today. Speaking of Twitch and Twitch streaming and video games, I'm probably going to start up a Twitch stream in a little bit. Very relaxed. Might play Risk of Rain. Might play some Elder Scrolls, Skyrim. Might play some other stuff. I've gotten a couple other games lately. I was kind of thinking about playing some Grim Dawn. They have a new expansion out. So I'll announce it on Twitter. I just need to check on my kids, make sure I get a little bit of a snack, little snacky, and then decide what game to play. But let me start playing the let's get that outro running, right? That's what I'm supposed to do. Supposed to run an outro here. Very unprofessional of me. Here we go. Let's get that going. All right, guys. So thanks for tuning in today. Oh, I've got a couple more. Let me turn this down a little more, because I do have a couple super chats that I can hit on the outro. I don't want to miss those. Don't want to miss those. Gelth Walker says, say Shane is a Mewling Quim, Loki style. Shane is a Mewling Quim. Billy the Max says, Tiberiticus is funny, play stupid games, win stupid prizes. Macca Jr. says, work late, so I missed your stream. Last stream to save for a house. My now wife and I were engaged for a year and a half. Can you say how embarrassing, Alistair? How embarrassing, Alistair. John Sargent says, can Ron be held to mortgage ethics review? Maybe. I wouldn't want to be convicted, or I wouldn't want to be found on the opposite side of a defamation lawsuit and found to have defamed someone publicly. Mortgage people tend to be similar to lawyers in that they have to have truthfulness. Defrauding, extorting, or otherwise public misrepresentative behavior can be very damaging to their careers. Jamal Breezy, thanks for the donation. Blackened Soul says, be funny if Ty subpoenaed their financial records and under oath have them talk about their cash sales from work and compare their W-2s. IRS probable. Their financial records in post-judgment discovery will definitely be relevant. Could be relevant earlier on. Automata says, oh no, what have you done? You just handed them the cut dungeon defense. Goru says, coke possession, TI. I mean, what's the difference? Really, at the end of the day, what is it? Ron Crossman says, hopefully the response will have the entire contract in it. Yeah, I hope so too. And then Nixhex says, this agency reminds me of certain Armenians podcast network. I really can't wait to buy my Faze bucks. Oh, rude. All right, guys. Thanks for the show. If you want to join me on Twitch, I would welcome it. Very much appreciate everything you guys do to keep this show going. And of course, check me out on Patreon if you want access to my Discord. And tomorrow is Wednesday, so there will be a live chat as there is every Wednesday, unless something dire were to happen to me. So thanks a bunch, guys. Have a good night. Peace. To the hills of Glenlivet, there's no one who explains the thought better than Nick. So pour out a glass for the ones who have passed to make the law what we